ಇದಾಯ್ತು. ಅಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕಲ್ಲ.
ನಾಲ್ಕನೇ ಮ್ಯಾಟರ್ ಅಲ್ಲ
ನಮ್ದು ಹೋಗೋದು ಸ್ಟಾರ್ಟಿಂಗ್ ಹೋಗ್ಬಿಟ್ರೆ ಹೋಗ್ಬೋದು.
10:00ವರೆಗೆ
ಕೇಳಿಲ್ಲ ಹೈಕೋರ್ಟ್ ಹೋದ್ರ ಅಂತ ಕೇಳ.
ಹೋಗ್ಬಿಟ್ಟು
ಹೋದ್ರೆ ನೆಟ್ವರ್ಕ್ಸ್ ಇದ್ದಾರೆ.
ಹೆಂಗ್ ಮಾಡೋದು? ಹಲೋ ಸರ್, ನಮಸ್ಕಾರ ಸರ್. ಬಂದ್ರೆ
ಇಟ್ಕೊಂಡು ದಿವಸ ಆದ್ಮೇಲೆ ಕಷ್ಟ ಇಲ್ಲಿ ಇಡ್ತೀನಿ. ಈ ಫೀಲ್ ಒಳಗಡೆ ಆಗ್ತದೆ. ಮಿಕ್ಸ್ ಆದ್ರೆ ತುಂಬ ಅಂಶ ತೊಳಿ ಇದನ್ನ ತಪ್ಪಲಾರ್ಗಳು ಎಲ್ಲ ಮೇಲಿದ್ದಾವೆ ಎಲ್ಲ ಡ್ರೈವರ್ ಒಂದೊಂದ್ಸಲ ಮಿಕ್ಸ್ ಆಗ್ಬಿಡ್ತದಮ್ಮ.
ಮತ್ತೆ release ಮಾಡಿ.
ಗಮ್ ಡೈಲಿ ಕೊಡಿ ಸರ್ ಸ್ಟಿಕ್ಕರ್. ಸರಿ ಇಲ್ಲ ಹಾಕ್ಲಾ? ಇಲ್ಲ ಹಾಕ್ಬೇಕಾ?
ಮೇಲೆ
ಮೇಲೆ ಹಾಕ್ಲಾ? ಸ್ವಲ್ಪ 20 ಇದಕ್ಕೆ ಹಾಕ್ಬೇಕಾ? ಇಲ್ಲಿ ಇಲ್ಲೊಂದಿದೆ
ಕೈಯಗಳು ಯಾಕೆ ಹಾಕ್ತಾರೆ ಇಲ್ಲಿ ಹಾಕಿರಿ? ಅದೆಲ್ಲ ಹಳೆ ಪೇಪರ್ಸ್ಗಳಿಗೆಲ್ಲ ಹಾಕ್ತಾರ. ಹೊಸದು ಯಾವ್ದಿದೆ ಅದಕ್ಕೆ ಮಾತ್ರ ಹಾಕ್ತಾರೆ.
ಇಲ್ಲ ಹಾಕ್ಲಾ ಅಥವಾ ಆ ಕಡೆ ಹಾಕ್ಲಾ?
ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು ಅಫಿಡವಿಟ್ಗೆ. ಹಲೋ ಯಾಕೆ ಬರ್ಲ? ಒಂದೇ ಹಾಕಿದ್ದು 2 ಸಾರಿ. ಜಗ್ ಮುಂದಕ್ಕೆ ಜಕ್ಕೋರಿ, ಮುಂದಕ್ಕೆ ಜಗ್ಗಿ ಹಾಕ್ಬೇಕು, ಜಗ್ಗಿ ತೆಗಿಬೇಕು.
To make a submission, my lords. It's an habeas corpus, my lords. The minor detainee has been secured from Bihar, my lords. Maybe taken up end of the list in chambers.
Chamber.
Please.
My lords had referred this case.
Yes, the other side, how will they know?
It's been informed to others.
You will.
Please.
So what time? 2:30?
2:30 or
2:30 in
or end
chambers?
of the list.
My lords had referred this case for mediation. The parties are willing to settle tomorrow at 2:30, my lord. The parties will be present.
They have,
They are agreed to settle.
Settlement.
Yes, my lords.
My lordship, writ appeal 808/2022, my lordship. In the last hearing, they mentioned 20th 2. Because, but in order sheet, but it listed on 20th 3, my lordship. In the last Friday also, I am move on the memo. It's a urgency, my lordship.
what is the urgency?
Madam,
What is the urgency?
in the suit schedule property, they build and construct a new building. Attu manege already pillar hakidare. On the basis and revenue entries, ma'am.
What date?
My lords,
Yes,
Tomorrow, my lordship, taken up tomorrow, my lordship.
my lords, stray vacancy round, my lords, KEA has not taken the seats which are surrendered. They have not surrendered. They allowed the candidates against your lordship's order, which violating that, they have allowed all the mob of candidates to participate without surrendering. Your lordships ordered those candidates who were affected by the 53 candidates, they were to surrender their seats and can participate. Which
those
KEA
who surrendered can participate.
can participate. They have not surrendered but allowed them to participate. Therefore, my lords, today is a provisional list allotment at 8 o'clock. Please, my lords, the matters may be taken up at the end of the list.
Tomorrow.
My lords,
Please,
today.
sir, please serve it
Yes, sir.
today.
Yeah,
They'll
absolutely.
get instructions listed tomorrow. Let's see.
Yes, my lords.
Yes,
Number 23. Memo for withdrawal.
please withdraw it. Please
Any
take it,
mentioning?
remove.
List 1, page 1,
Copies.
seal number
You've signed. File.
1 is filed in the file, second one is page.
Twenty-three.
List 1, page 1, seal number 1 and 2. Page 2, 3 to 5,
Your lordship,
page 3,
serial
6.
3, your lordship, I have heard the appellant, your thought accommodation of the granted.
BTM 6 stage, it's all,
Lordship,
item 7 is also the same.
your lordship is connected. We want to seek some instruction in that, your lordship.
Please be here. Yes,
Page 3, 6 and 7. Page 4, 8 to 11.
Serial number 8, my lord. I appear for in both the matters. I represent respondent number 3 and 4. I pray for a week's time, my lord. Records are also yet to be received.
between
Repetition
tenants and
45.
purchasers,
Yes, my lord.
correct?
Arguing counsel is not in station today. I pray for a short accommodation.
Records are in the repetition, at the time of,
They're here,
yes, madam,
they're already here.
yes, madam. Already it's in the repetition. Record on that.
Please,
Hold on.
please see that the records are here. Have you informed the other
I
side?
have informed the other side.
When?
From 27, 28 also it may be taken.
Impossible. Give a date after. Yes,
7th, 7-3. Page 5, 12 and 13. Page 6, 14 to 17. Page 7, 18 to 20. Page
there also there is a
memo for
memo for withdrawal 19. Same order.
page 9, 21 to 24. Page 10, 25 to 27.
Yes, 2 weeks time.
Page 11, 28. Page 12, 29 to 32.
32, my lord. I appear for respondent, they will inform the others, they will speak for a short accommodation.
2019 matter, Succession Act,
Serial number 31, my lord.
the request of the learning council for the respondent. You've informed the other side?
Yes, ma'am.
Yes. 2 weeks.
Serial number 31, my lord.
Yes.
This matter is connected with
It's still on.
Connected with
Number really, number.
Page 13, 33 to 36. Page 14, page 15, 37 to 41.
Serial number 39.
39.
Please, for respond number 1, I inform the appellant. The appellant is also here. I place
And
to-
acquisition. Which is this acquisition?
The land is. The appellant is here.
Can be.
Yes.
Serial number 37 malada. Hearing for appellants malad kind 2 weeks time. Today my senior niece marriage malad. That's
With the request. Yes.
Page 16, 42 to 47.
This matter,
Yes.
my lord, if your lordship read,
VDA.
this is, yes, RMB second stage, my lord, last week, your lordship. This is very similar order, my lord, pursuant to the order passed by the learned single judge. The other learned single judge has passed the order. Last week, we had briefly argued before you. So your lordships have listed all the batch matters on 19th.
List along with, will you please give
Give
a date?
the
and start?
number. 19th March,
I mean, the numbers.
please.
Yes.
Page 17, 48 and 49. Page 18, 50 to 52.
My lord, serial number 50, my lords. Senior counsel has to argue due to personal inconvenience, he is unable to appear.
T22.
50, my lords, serial number 50.
Never.
Writ petition number 9568 of 22.
You are for petitioner.
For the petition, I have informed the other side also, my lords. After 2 weeks, if it's convenient to your lordship,
Yes.
2 weeks. Obliged, my lords.
Page 19, 53. Page 20, 54 and 55.
54, my lords. I appear for respondent in the case, my lords. I seek for a short accommodation.
Have you informed the other side?
No, my, I'll inform. I tried calling him, but
Please don't make submissions without informing the other side. How will they know? Yes. The request.
21, 56 to 58.
Yes, 3. Okay. Wait here. Oh, I didn't see that matter. Memo with code C exemptions.
ಎಲ್ಲಿ ಬರ್ತಾರೆ ಇಲ್ಲ ಸರ್
So
ಸರಿ
they
ನಾವು
are-
ಈಗ ಸಿ ನಮ್ಮ ಇದ್ರ ಪ್ರಕಾರ ಯು ಶುಡ್ ಗಿವ್ ಎನ್.ಒ.ಸಿ.
List 3, order, seal number 1, Sumitra JM.
ಸೊ ನೀವು ಯು ಹ್ಯಾವ್ ಟು ಗಿವ್ and you have no objection. ನೀವು ಇದನ್ನ ಕೊಟ್ರೆ ನಾವು ಇದು
Pass over, let's.
List 2,
ಮಾಡ್ತೀವಿ.
seal number 1, orders,
ನಮ್ದ
Sirajuddin Ahmad.
Lord, I have filed my statement of
Petitioner,
objection. But I'm sorry, only one set was filed, the other set, if I may hand over. I'm sorry about that. Lord, in this, would your lordship kindly have a look at, page number, ilwa?
Annexure 6, sir.
Page number. Annexure 6, my lord. I'm sorry. Annexure 6, which is a communication by the Ministry of Home Affairs. Lord, that sets down the procedure to be adopted for repatriation of different nationals. Para 4 in Annexure 6 deals with the procedure with regard to repatriation of
28.
page 28. Lord, page 28 lays down the procedure with regard to repatriation of Pakistani nationals who are arrested. And if I may read the procedure, in the case of Pakistani nationals who are arrested, the repatriation is done in terms of the agreement on consular access signed between the Government of India and Pakistan on 21st May 1988. Such Pakistani nationals can be repatriated only after completion of the sentence, court proceedings, grant of consular access, confirmation of nationality, and issuance of travel documents by the Pakistani High Commission. Decision on repatriation of such Pakistani nationals is taken by the Ministry of Home Affairs after the following aspects are compliant. A, state government concerned has confirmed that no other criminal case is pending against the particular Pakistani national. And my lord, second is important. and that they have no objection to his or her repatriation. B, nationality of particular Pakistani national has been confirmed by the Pakistani High Commission and the requisite travel document has been issued in his or her favor. So therefore, Lord, A and B are very critical. The B will kick in my role as central government only after the state government says two things. They should first confirm in writing that there are no other cases against that Pakistani national. Secondly, that they have no objection for the repatriation. Once that is given, my lord, I will verify with the High Commission, and if they identify, we will deport him.
I am appearing for respondent state my lords 1 and 4. Objections is ready. I will file my lords in the registry. My lords, with regard to my lords, learned counsel has made submission that my lords, state government has to give no objection. That just now I came to know. Just I will go through the objections, my lords, which I will seek a copy of my lords. And my lords, any of my lords, one case is pending against my lords, this petitioner.
What is the nature of the case pending against it?
My lords, state has preferred appeal against acquittal, my lords.
What is the nature of the case?
Offense against state, my lords, because he has been arrested under terrorist activities, my lords. For that, my lords. And
That case he has acquitted, lordship.
that's what, my lords. I made submission that appeal against acquittal is pending before this honorable court. And my lords, notice has been served. And my lords, counsel, my lords,
We have already recorded that. We just want to know the nature of the case. What
that
is
time, my lords.
Is that part of the objections that you're preferring,
Lords,
the acquittal order?
the offense they have not mentioned, my lords, but I remember, my lords, it is waging, my lords, he is involved in terrorist activity.
Yes, what is this criminal appeal 2002?
Yes,
You
my
have a
lords.
copy?
I will furnish, my lords. My lords.
We did not file it. We'd just like to see what the.
Report
This is a-
ಮಾಡ್ಬಿಡಿ ಅಂತ
It may
ಹೇಳ್ತಾರೆ.
pass over, my lords. Right now, my lords, I don't have the copy.
In fact, my lord, annexure 10, page 44. Page 44, annexure 10, I'm sorry, which is a Kannada document.
Yes,
The state authorities write to the center and they request not to deport. They write to the FRRO, Foreigners Registration Office,
This is
and they
not
say, do not
21
deport because we have filed an appeal.
2125.
Yes, my lords. So as of now, my lord, we have to await the confirmation by the state authorities. Thereafter, we will take.
It may pass over, my lords. I will give the copy, my lords.
Confirmation regarding lordship, they have already confirmed lordship. From 2010 only, they confirmed he is a Pakistan national.
There.
Kindly see this.
File it, please.
File.
Please place it. It is on record.
I have not, at least I
There is in
I have
Have
not.
a copy and place it on record now that the,
Kindly have it on 27th lordship. We have a detail in that detainee lordship is suffering lordship.
not 27.
ಬೇರೆಯವ್ರಿಗೆ ಊಟ ಮಾಡ್ಕೊಳಕ್ ಕೊಡ್ತಾ ಇದಾರೆ ಬಟ್ ಅವ್ನಿಗೆ 24 hours ಲಾಕ್ ಮಾಡಿ ಇಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಊಟ ಮಾಡ್ಕೊಳಕ್ಕೂ ಕೊಡ್ತಾ ಇಲ್ಲ ಇವರು.
Yes,
27th lordship.
6-3.
I'm great.
27th lordship because
Please
some
place
food problem is
everything-
going on the detention center lordship.
Just a moment.
I will
please.
place it on record, my lords.
Place it on record in advance so that they can
Definitely, my
file
lords.
their, anything that they have to file as
Yes.
against that also they.
Yes, my lords.
For other foreigners, they are making themselves to cooking lordship. For him, they are not allowing lordship. Kindly pass the order for that also lordship for till that date lordship.
Lord, may I seek one more indulgence? I had earlier not given the second set. There is an office objection that may be overruled now. I have handed over the second.
Yes, yes.
List 1, admission, seal number 1, Basuraj Patel. GK.
This is the appellant's counsel. Pass over, let's see.
Number 2, Prithvi Shemke.
The income director,
Income
seniority.
Seniority.
Can you hear this?
Yes. Great.
Please.
Yes. Great.
Please.
Three, Urgesh Vichar.
3 and 7 are both BTM 6 stage, please, madam. Like 30 acres in this village, where is the 30 acres? Where has the layout been formed?
So in 30 acres, this land is also included in the 31 acres, my lord.
Where? What is there to show that?
3 and 7, both are from the same.
Same,
3 and 7.
3 and 7.
3 and 7. Can we,
R7.
7 is also Hulimavu.
7 is also same.
Same scheme, same village.
survey number is different, my lord.
Survey number may be different. Just show us where has the layout been formed.
In that plot, the vacant place is our property. What is left in the center in the exact middle,
If it comes within the
survey number 9.
layout. It comes within the layout.
Huh?
Within the layout form. Yes. See, this is the playground. It's the playground. If it is within the layout, it will be like this. If it is this, if it has not been taken, it is not part of the layout. Don't worry, 10. Well, this is. Yes,
In survey number 9, they are marked, survey number 9 marked as a park, my lord.
survey number 9.
Marked as a park. We received,
Yes.
today we received the photocopies, my lord. 2 days time may be granted. We will file along with the memo, my lord.
Even within the layout, there are clearly marked private properties. And this property, there is a road passing through and layout on either side, but nothing there.
The statement of
You
objection.
have taken over and formed something that is also marked here. Please see, within the layout, there are parks, open spaces,
Yes, survey number. marked.
playgrounds. All that is all within the layout areas, there are parks and open spaces. No difficulty. This is not like that.
Authentic.
It is part of the approved layout, but not formed.
Formed, my lord.
This is how this map shows like
No, my
that.
lord. Today,
This
I
is,
received something.
this is not something they have created. It's part of your records. So it shows. There is a stone quarry, there is
Can
a
you pass over, my
temple.
lord?
Before the single judge also, no such defense was there.
Passover,
Can you pass?
senior counsel, can we pass this
Before-
over today?
Notes.
3 and 7. Sorry,
The connected matter, I'm agreeing for the.
3 and 7.
Yes.
Same issue here.
Same issue.
Whether it is part of the
Yeah.
layout, whether
It is part of the layout, my lord. My lord, one-
Does not
one
look like that.
submission- One submission, my
Hmm.
lord. In my petition, my lord, the respondent has filed a statement of objection.
Hmm.
Along with, there are 2 annexures, my lord.
Hmm.
There has been produced wrong.
Okay, sir.
Earlier, I produced it, my lord.
Film must
They will
be
post it, my lord,
easy.
some next week. Immediate, my lord, shall give you that. Wrongly, my lord, kindly, I'll show that, my lord. I'm not seeking, my lord, much time because.
question of a log rope,
Yes, ma'am.
Oh, but.
let them produce. The
no, but
question is
they are
only
raising
this,
it
Yes,
in-
ma'am. I understand, my lord.
is it part of the layout?
Yes, ma'am.
Has a layout been formed in the,
Part of the layout. One submission is that.
When you notify 388 acres and form a layout in 31 acres, you cannot say that it is substantially formed.
Then also, my lord,
Next week, any date, my lord.
then also the question would be whether the layout is substantially implemented or not.
Sure,
Even assuming
substantial.
one portion is implemented, then also it will lapse. That issue
Correct.
will have to be considered.
Yes.
And no such.
Award was
defense
passed,
taken.
award amount was deposited, my lord. It's a 16-2 notification was issued
And then,
in the both matters, my
and
lord.
then
Possession was
nothing.
taken in the year 2000.
Absolutely nothing.
Yes. It may post it next week, any date, my lord. I'll rectify the things and I'll come back, my lord.
It's going on like this, you know.
Any date.
Single window on the 9 times.
5-3, 5-3. 3 and 7 together.
Fourth, government advocate.
Take it 230, my lord. 230.
Permission to grant
Fourth time it is being
prior service, Passover,
230, my lord.
Passover, let's see.
passed out.
Number 5, Sagar BB.
But the respondents.
957 of 22. First sale in 1957.
There is a 32 years delay in filing.
Passover.
Six, Abhilash Raju.
My lords, I appear on behalf of the appellant. I would request for a short adjournment. My lords, I've already informed the other side as well. The counsel leading me in this arguing counsel is unavailable this week for a personal inconvenience.
What do you say? Next week? Counsel for the appellant seeks a short accommodation this next week.
Preliminary,
Grateful, man.
7 adjourned. 8 adjourned, number 9, Srinivas V.
My lord,
Filing on short synopsis, you will ask for brief synopsis, my lord.
the
63
short point, my lord, in
acquisition.
this.
Award in
Not awarded, my lords. I will just give only 4 dates. This is an acquisition under the 19 knot. City of Improvement, Mysore Act of 1903. Under 1903, though it acquisition, my lord, is under section 16 of the Act. The provision of the Land Acquisition Act is deemed to be made applicable in terms of section 23 of 1903 Act. Then, my lord, 1903 Act has been repealed in 1987 by Karnataka Urban Development Authority. Now, my lord, preliminary was 63, 1912-63, final on 25-3-1969. The award came to be passed on 3-10-1975. Till today, neither the amount compensation amount is remitted to the court or it was tendered to the owners. And possession is also, my lord, continued with the owners. Now, my lords, there is one in the original suit, the commissioner admit, page 255.
what was the suit for?
Suit for injunction, my lord, that came to be dismissed.
Suit in respect of acquisition is not maintainable, my lord. They
Absolutely.
got.
I am not on that. I am only an admission in the pleading page 255, paragraph 11. The first defendant further submit that the plaintiffs have filed the suit for permanent injunction by stating they are in possession of the scheduled property by constructing the house and residing the same without these properties. No other properties to lead their life. Yes, they are in possession of the suit scheduled property, but the said possession is illegal by the reason of the will take action to evict them in accordance with law. Now, my lord, this is one aspect. If your lordships kindly come to page 258 minutes. There is a report submitted by the authority that there are 7 family members of the owner and each of them have constructed a house 30 into 40, 35 into 40 and they are in possession. Let the translated copy is at page 258. Now, my lord, this is 2013 minutes. And now they have incorporated 2013 Act in 2017 amendment, not only to section 36(3) of the Act and also the allotment rules. They have framed the 2009 rules. In lieu of compensation, allotment is permitted. Now, my lord, we are residing in 7 houses. Possession is not taken. Compensation is not paid till today. The 2013 Act has been incorporated into Section 36 of the Urban Development Authority by way of substitution.
What do you say on the second finding? Finding to point number 2. You seek an alternate site, which means you acquiesce to the acquisition. Then you cannot challenge it. After having sought an alternate site, you cannot.
That
further
was
challenge.
not granted to us.
Whether it was granted or
Well,
not.
that
is
was not
the question.
granted to us.
Whether it
So
was
far as
granted or not is not.
that
the
I
question.
concede, my lord, I concede. When a petition has come up for prayer for alternative site, my lords, and there is a rules of 2009, in lieu of compensation, site can be given. Now an endorsement has been issued. There is no provision to grant you the site. Therefore, the right has been switched over to section 24(2) of the Act in view of 2017 amendment. 2017, my lord, 2013 Act has been incorporated. Therefore, a fresh right has been given to me. Now, as on today, we are in possession of the property. We are residing there. Under 2009 rules, if they allot me an alternative site, my learned friend is representing Aditya Inchinagiri. It has not been allotted. This site has not been allotted, but neighboring land has been allotted. My learned friend. Only the Muda has to respond to your lordships.
I appear for appellate. Muda, yes. My lord, this is the third successive
allotment, my lord, K.N. Puttegoda was appearing, your lordship. K.N. Puttegoda was appearing for the trust, your lordship. Education trust, Adjournments Education trust, your lordship. Apart from that, your lordship, they have challenged the allotment made in favor of the trust also. They did not succeed, my lord. That writ petition is, they challenged the allotment made in favor of the trust. That is before this honorable court. My lord, may kindly see the
This 11 guntas of land is
petition
neither
filed by them.
allotted nor there is a writ petition.
There are successive writ petitions, my lord, which has been filed, my lord. This is the third successive writ petition challenging the acquisition of the year 1963 after lapse of 49-50 years. Much water has been flown, my lord. City has been developed in like, kindly see, my lord, annexure, page 206, annexure J for a moment. All the petitions, my lord, have challenged the allotment of sites made in favor. It is a CS civic community site. Reserved. Final 206, my lord, got it, my lord.
Yes.
The preamble, your lordship could kindly see, my lord, the order. Writ petition is filed under Article 226, challenging the allotment of site number 148 to the second respondent. This is the site allotted to the trust. This has been challenged by them. They did. This is the order passed. The contents of the learned counsel so and so. Petitioner that the petitioner is in adverse position. That is the claim made by them. That has been rejected. Next, my lord, next writ petition, my lord, may kindly see. Page 210. In the J2, my lord. J2, that is also challenged by one of the appellant before this honorable court, my lord. That also came to an end. Then, my lord, they have filed a writ petition, my lord. When they did not succeed, my lord, challenging the allotment made in favor of the trust, your lordship, they filed another writ petitions, my lord, may kindly see. Annexure J4, my lord. Challenging the preliminary notification. What is the right to challenge, my lord? Now, yes, in a third round litigation, my lord. Page 222. Filed by them. There is no dispute that large extents of my lord got it, my lord. This is the third round of litigation. One after the other, getting order, passing resolution. My lord got it, my page 222, wherein the acquisition has been challenged, my lord, by the appellant. Annexure J4, 221, it starts, my lord. 20,874. There is no dispute, page 222, my lord. There is no dispute that large extent of land, including the of land, including preliminary notification, dated 1912-1961 Trust Board Act, 1903. Notification dated so and so, which is not called and therefore disentitled the relief of quashing the competent civil court, quashing the Annexure D, allotting the civic community site, which includes the land in question by the second respondent, by Mysore Urban Development Authority, so and so. The allotment made in favor of the trust, my lord, has been confirmed.
My lord, I am
Then also,
sorry
my
to
lord, may kindly see,
intervene.
my lord. Annexure, no,
These
I will complete. I will
allotments are
complete.
not included in 11 guntas.
Page 225, my lord, may kindly see.
Only
J5.
clarification.
J5. There also, my lord, they have challenged the allotment. The notification was discussed, issued in 1963. They did not succeed. Then, my lord, they filed a writ petition to stop formation of road. Annexure J6. Several writ petitions, one after the other, they are filing. It is an abuse of process of court and law.
Same situation.
All successive writ petitions, then suit. Then suit has been filed. Then, my lord, they withdrew the writ petition. So they will seek remedy, my lord, to seek allotment of alternative site. That came to be rejected, my lord. That was not challenged. My lord will get it, my lord, annexure Q series. That remained unchallenged, your lordship. Your Lordship will get it 270, Q series, my Lord. This was issued, my Lord, on 16/5/2016, 270. Kindly come to operative portion, my Lord, 272. While considering their application, my Lord, as per the direction of this honorable court, for alternative site or something, my Lord, incentive sites. RSA number so and so, my Lords got it, my Lord, 272 page. RSA number so and so, it is in English. Gana Ucha Nyayalaya RSA 1164 of 2011 connected with RSA 36 of 2010 ತೀರ್ಪು ಮತ್ತು ಡಿಕ್ರಿಯಲ್ಲಿ ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶ ಮಾಡಿರುತ್ತದೆ. MUDA is the successor in the interest of the CITB. MUDA being a creation of a statute, its power are circumscribed by the statute. It is well settled that a public body invested with the statutory powers has to take care not to exceed or abuse its powers. It must be within the limits of the authority committed to it. The power, much less the Karnataka Urban Development Authority Act 1987 has not conferred upon the MUDA any inherent power. My Lord, may kindly note this, Your Lordship. MUDA an inherent power, much less an discretionary powers to allot alternative sites in favor of the plaintiffs during the relevant point of time. MUDA being the custodian of the public properties, he is not as free as an individual in selecting the recipients for its largest. For allotment of properties, a transparent and objective criteria procedure has been evolved based on reasons, fair play and non-arbitrariness. The allotment of sites are governed by the Act and rules made thereunder, and the allotment of sites has to be made strictly in accordance with the provisions of the Act and the rules. The predecessor of the plaintiff have received the compensation for acquiring their lands. Therefore, they are not justified in seeking allotment of a site, that too after lapse of 30 years. Here, my Lord, for more than 49 years, 63 acquisition. The civil court cannot grant mandatory injunction to the MUDA for allotment of site contrary to law. Therefore, even if this MUDA had allotted a site in favor of L. Shivanna, a court of law cannot direct the MUDA to allot a site on the similar footing. The question of law framed as above is answered accordingly. Therefore, my Lord, their application for allotment of alternative site also, my Lord, came to be rejected. This remained unchallenged, my Lord, since 2016. Q series, my Lord, is endorsement issued to everyone before this honorable court. All these points, my Lord, has been considered by the learned single judge, Your Lordship, and thereafterwards, my Lord, writ petition came to be dismissed, my Lord, by passing a detailed order. And delay, there is no explanation for delay at all, my Lord, in this writ petition. There is no explanation. They file one writ petition, they won't disclose it in another writ petition. They take one order in another writ petition and go before the authority. The conduct of the parties must be appreciated, Your Lordship. If this is allowed, my Lord, there will be, it amounts to opening up a Pandora box. And one writ petition, my Lord, page 262, my Lord, where the appellant have filed writ petition challenging the acquisition. My Lord could kindly see, my Lord, in 2012. The writ petition is filed para 263, my Lord, page. Yes, Your Lord. How are they entitled to get relief is the question, Your Lord.
This is specifically with regard to this 7/1B 11 guntas.
Yes, Your Lord. That is their case. They are the owner of the land. That is a part of a civic community site.
Draw the writ petition with liberty to pursue the application.
Yes, Your Lord. They filed application. They had filed application for alternative site. It came to be rejected in 2016.
Yes. Yes,
But I'm only on two issues, my lords. All the writ petition which my learned friend has taken to your lordships would be the alternative site allotted to the Adi Chunchanagiri in respect of other lands, not just 11 guntas of
no,
land.
it is 11 guntas.
No, my lord.
The portion is also attached.
262 page, please.
Pardon, my lord?
Page 262, WP number 50208 of 2012, specifically 7/1B, 11 guntas.
That is, my lord, the acquisition is challenged.
You are seeking a allotment of a alternate site,
No, no, it
which
is-
means that you're acquiescing to the acquisition.
No, no.
And there is specifically 11 guntas in 7/1B.
My lord, the prayer
Very
is
same petitioner.
correct. The prayer, my lord, to quash the preliminary and final notification. This court said you go for incentive scheme. That is how a
That
state.
means you acquiesce to the,
My lord, I concede, my lord. This order is in 2013. 2013.
yes,
The request for the incentive scheme was turned down in 2016.
yes,
Now, my lord, with these facts, I am only submitting to your lordship.
yes.
In 2017 amendment, the 2013 Act has been substituted to section 36.
Please give us the amendment.
ಸ್ವಲ್ಪ ಇದಪ್ಪ ನೀನು.
That cannot be given to, there is prospective lordship that cannot be incorporated to 100 years old act, your lordship.
Please give us the amendment.
ಇದೆ.
ಅಲ್ಲ ಅದು ಬೇರೆ ಇದು ಬೇರೆ ಇದು ಕೇಳ್ಜೆ ಇದು ಕೊಡಿ ಕರೆಕ್ಟ್ ಆಗಿ ಪೇಜಿನ ಎಷ್ಟಿದೆ. But kindly go to your lordships, page 59 of the book, my lords. I will just read 36. Provisions applicable to the acquisition of land otherwise than by agreement. The acquisition of land under this act otherwise than by agreement within or without the urban area shall be regulated by the provisions so far as they are applicable. The right to fair compensation and transparency in land acquisition, rehabilitation, and Resettlement Act of 2013. Then, my lords, for the purpose of local authority subsection, then 3. After the land vests in the government under section 23 of the 2013 Act, the Deputy Commissioner shall, upon payment of the cost of the acquisition and upon the authority agreeing to pay any further cost which may be incurred on account of the acquisition, transfer the land to the authority, and the land shall thereupon vest in the authority. Now, my lord, if your lordships kindly go to the same book, the page 120, my lords. Sorry, 119.
Yes,
The Karnataka Urban Development Authority's allotment of sites in lieu of compensation for the land acquired rules of 2009. Then, my lords, rule 3, if your lordships, without prejudice to the provisions contained in the Karnataka Urban Development Authority's allotment of sites rules of 91, with a view to speed up the land acquisition process free from litigation, the authority may purchase or acquire any land under section 35 or 36 and make allotment of sites in lieu of compensation determined in accordance with the provisions of the right to fair compensation and transparency in land acquisition, Rehabilitation, Resettlement Act of 2013, or by mutual consent, the owner of the land subject to the following terms and conditions. If the owner agrees for the sale or so and so, all encumbrance, B, my lord. If the owner of the land agrees to receive compensation in the form of residential sites, proportionately accounting for not less than 35% and not more than 50% of the land reserved for residential purpose in the layout, the percentage shall be determined by the concerned authority depending on capital cost and the market value of the land. If the compensation is more than the amount of the value of a dimension of a site allotted, the excess amount payable over and above the value of sital dimension shall be paid in cash. The procedure and method in specified 2013 Act, and there shall be mutatis mutandis apply for determination of market value. But the submission which I am making on behalf of the petitioner should be twofold, my lord. If 2017 Act is substituted to Section 36 of the Urban Development Authority Act, Section 24, my lord, has to be read into it in 2017 by way of substitution. Therefore, the prayer has made in the writ petition that not one thing
They give effect to this OL. We have nothing to say. As per the terms of this. We made a submission on the last occasion that we are withdrawing this notification. So therefore, we are putting the way the outside exam.
Yes.
So
Speak.
far as 1903 Act is concerned, there is no provision for lapsing because it is under the Acquisition Act of 1894. Now, my lord, so far as the Urban Development Authority is concerned, Section 27 is pari materia with that of the BD Act, my lords. So far as the implementation of the scheme in respect of a survey number is concerned. Now, my land of 11 guntas of land, if it is 1963 acquisition, 75 award is passed. Till today, compensation is not tendered to me, nor it was deposited in the civil court. Therefore, my lords, Section 24(2) prayer has been made, number one. Number two, there is already an order passed by the MUDA, my lord, releasing the land on the ground that possession has not been taken, compensation has not been paid. That is on 25/10/2023, which we have placed it on record.
Where is that?
One memo have been filed. Along with that, one official memorandum have been.
Blood, it is not translated, but the contents of it is possession is not taken, compensation has not been paid. Therefore, 3,235 square feet is being allotted to these petitioners, and we are prepared to withdraw the writ petition.
What is that? Do you
That
have
is-
copy?
That is an order passed by the MUDA.
Possession has been taken in 1982 itself, your lordship, under, same has been gazetted, my lord. a notification was issued in under section 16(2), my lord.
Now, is this addressed to you
Yes,
with regard to your property?
Yes, madam.
No,
7(1)(b).
There,
1023, what
my
is
lord,
that?
that resolutions, my lord, is subject matter of all these scandals, your lordship. Now thereafterwards, my lord, all these scandals of Muda, government has issued a notification saying that don't give effect to any this thing. Last week, I brought to your lordship's notice, your lordship. Therefore, that resolution, any past, my lord, commissioner or the board has not given any unfettered power under the act, my lord. They can't go beyond, travel beyond the order passed by this honorable court. They failed in RSA also. They failed in before this court also. My lord, may I kindly see the another writ petition which has been filed, page 375 also, wherein they filed a writ petition, takes liberty and goes before the court and use their influence and get one or the other order. Who are the authorities to pass such kind of orders contrary to the order? That is what the observation made in the RSA. 375, my lord, may I kindly see, my lord. 375, my lord, all the petitions, complaints before this honorable court filed a writ petition
Yes.
challenging the acquisition.
Yes,
2030, annexure R9, my lord, got it, my lord, page 375.
yes,
There also they have challenged the acquisition proceedings. Then, my lord, they withdrew the petition. Kindly see the memo filed by them, my lord. Memo placed, page 378 is the relevant page, my lord.
yes,
Memo is placed on record, writ petition dismissed as withdrawn. The MUDA is directed to consider the application referred to above in accordance with law. How many times they have to challenge the acquisition? How many times they have to issue take direction? How many times we have to consider is the question.
yes.
Therefore, writ appeal is liable to be dismissed
My
with
lord,
exemplary
this,
cost.
the order passed by the MUDA is based on 2009 rules, my lords.
They can't apply 2009 rules at all. It will be a precedent in the event if it is followed.
Yes. Yes, sir.
But there is no evidence produced before this court withdrawing 25/10/2023 and not been paid compensation, possession is not taken according to the resolution of the MUDA.
Didn't put it.
Therefore, my lord, the
82 position
proceedings have
taken,
been
your lordship.
lapsed. Beyond this, I can't put it, my lord, that's the position. In view of 2017 amendment, there is a right guaranteed to,
Yes, we'll consider.
and we are residing there.
Yes.
10, Satyanand BS.
My lord,
One second.
only the
One more.
sketch, my lord, we are just passing on to your lordships.
Cannot make any difference.
allotment,
How can we
the
rely on
same
a
survey
sketch?
number to other persons in 2018.
How can we rely on such sketches that are happening?
Brother of the
We cannot
petitioner,
rely on.
one second. Brother of the petitioner was in a similar position. He has been granted alternative site in the year 2018 with respect to the same survey number. May I just place it on record, those two documents.
Consider that.
It's an adjoining land.
Adjoining land. Survey number is also 7/1B.
Yes.
Obliged.
Yes, sir.
Responded.
10, Satyanand BS.
Yes. Relinquishment for board widening. Can we pass it over? Pass over.
2:30. I'll be here, ma'am.
Pass over.
Yes.
Probably it will reach only by 2:30. We have two other matters passed over. And we have quite a long list also.
I'll be here by 2:30. Okay.
Hearing on IX, number 11, Ganesha Prasad party in person.
Yes, interlocutory application.
How did he join from gate number 5 to little intervals and I reached it on 24. Meantime, I also applied for the certificate copies which are yet to be issued, which has a direct bearing on the submissions in the present appeal.
What is the IA now being moved?
This is the matter, Lordship, kindly, this is regarding the preemption right. As the third or
Yes.
fourth time, he is expressing his personal difficulties. Preemption, the right of preemption, last time, your Lordship has made it very clear, it has to be heard today. Still, my learned friend is asking the time.
I'm not able to stand. I'm not able to walk also with gate number 5, it's not a effort. Not to remain absent, I'm being present.
2012 appeal.
Yes.
Well,
Either please argue, otherwise we engage.
My humble submission is that in view of the settlement development, I pray time because it will save.
absolutely, there is no,
What is- What is the settlement?
Settlement is, it's a package of offshoots of all the main matters before the company court. And the evidence discloses. It is clear that it is an offshoot and it is around.
Mr. Prasad, what is the settlement?
Settlement in the sense, my lord, is considered that all the offshoots, including the main matter that commenced in 1988, which was only before, by and between the same parties. And the evidence also discloses why the subject jurisdiction has been invoked. Page number 273, my lord, of the paper book, it may kindly be perused. My humble submission is to see that not to waste the court of hours of this honorable court, as well as pending matters before the other courts, as well as on the original side upon disposal of the matters pending before the honorable high court. So under circumstances with genuine hope and strong hope for settlement, by and between the same parties, cluster of matters pending ever since 88, and all the offshoots later to 88, which the evidence also throws light and exposes about the cause and the maintainability and the evidence also throws light the genuineness on my appeal.
Mr. Prasad, is there a settlement?
Yes, madam.
If there is no settlement, we are hearing the matter.
I got a strong hope.
If you want to argue the matter, you can. If you cannot argue the matter, we'll engage a counsel for you.
Not a physical inability,
Therefore, will,
my problems have not been,
do you want a counsel to be engaged to argue your matter? Do you want a counsel to be engaged to argue your matter? Then,
arthritis. I am before this honorable court. My genuine, my humble submission is that my physical inability may be considered.
shall I make one request? Ma'am?
yes,
If he is not in a position to stand and argue, your Lordship may kindly permit him to stand and argue.
definitely.
My shooting pain is dragging my attention of the mind.
Mr. Prasad,
Yes, my lord.
you can sit down and argue.
No, my lord. Shooting is not a problem, my lord. Shooting pain is there. I'm not able to
If-
concentrate.
is there an interim order in his favor? Is there an interim order in his favor?
No. Not
You can
the question,
proceed.
not the
If
question.
he refuses to argue a matter, you can proceed with the execution of the decree.
Now the.
Yes.
No, this is this is regarding the preemption right. There is a partition between him and his father in the year 1975. But they are in father and son, they are not in good terms. In my parents, everyone is not in good terms. But in 1986, there was an agreement in the partition, there is a preemption clause. And if father intend to alienate any of the part of the property, he has to give first option to his children. And he wanted to dispose of the property, mother and father both. And mother, of course, she has executed the gift deed in favor of one religious institution, that Dharmasthala institution, that he has challenged. Ultimately, this honorable court reject.
Please.
1 minute, please wait.
Please, Mr. Prasad, we are listening to.
That has been rejected. Then what this is, the father wanted money for his personal needs and other things. He invited him. If you intend to purchase the property is not less than 60 lakhs rupees. If you are interested, you purchase. He has issued notice to him and also to his brother. Brother said, I am not interested. He said, he has sent a reply making all sort of allegations his father and mother. And he said, you are unnecessarily selling the property. This property is not valued. All this contention he has taken. Then ultimately he has waited for 90 days and sold the property. We purchased it for 60 lakhs rupees exact. Then he has filed a suit after nearing just 2 days prior to 1 year is a limitation. He knows everything. Because they filed a suit and he has contested the matter. Several contention he has taken, saying that there was some interim order that has been refused. And the company cases, all these things have been ultimately learned trial judge held that this preemption clause is properly invoked. You have not opted. Your intention is only to deprive the right of your father and to dismiss. Against that, he filed this appeal.
Hmm.
And now, my lord, in the appeal also, you last may kindly see the prayer. It is a very strange prayer. He sought. Paper book, you last may kindly see. And my lord, in the suit, my lord, there was page 11 of the paper book. Decree, you last got it, my lord. Decree for, last please see this. For a decree directing the defendants 1 to 3 or such of the defendant as the court deems fit and appropriate after settling the actual market value at which the suit scheduled property is to be sold to the plaintiff, as on the date on which right of preemption arose to the plaintiff in terms of clause 18 of the partial partition dated 28/3/1975 to execute and register the sale deed.
Consequently, decree is the plaintiff.
But practically, it is in the nature of, practically it is the nature of specific performance, saying that preemption right is there, you direct because that the purchasers and the father to execute the sale deed. For this price which will be determined. One more request, my lord, one more request. If he is incapable, let him file a written argument. You will not. And please consider it for final. The reason is this.
Yes.
We purchased this property.
Mr. Prasad, we are giving you one last chance. You either,
Physical inability, despite which lot of effort I'm studying, I'm not able to stand.
please
The lordship.
file your written-
I'm not able to sit also, in pain, my lord. I never wanted to get upset before this honorable court. I wanted to.
we'll give you one more opportunity. If you don't argue the case on that date, we'll hear the other side and pass orders. Yes, at the request of the appellant who appears in person, one last opportunity is granted to make the arguments. If arguments are not addressed on the next date of posting, the matter will be heard as if the appellant has no arguments to place on record. List on, what date do you want?
Anything of the 3 weeks, not beyond, not earlier to that, because.
2 weeks. List after 2 weeks.
Please.
Yes. Please give a date.
You will actually kindly, yes, need a date also.
24/3.
Please.
Yes.
I'm for the state in this case, my lord. My lordship has directed us to be file the report of the survey for the encroachment.
Yes.
My lord, we have received that is on 30/12/2024, my lord.
Yes.
The comprehensively along with the affidavit we will submit, my lord, weeks time
last
with
time.
it because they should not take undue advantages of
Lord,
this affidavit. my
There
lord.
was encroachment.
Yes, my lord.
Lord, report was called for. They confirmed the encroachment, but they were not in a position to give the particulars, which is why the court said that they must
No,
give the
we-
particulars as
We,
well.
we have got
Let
it.
them
my lord.
file it, my lord.
No, we are filing. We have got it with the comprehensive, my lord,
No, no.
along with the affidavit we'll submit.
Didn't the order passed on the last occasion? My lord,
Yes.
they have, today, the matter is before your lordship to hear an IA number 2.
What is IA number 2?
A number 6 also.
One of.
IA
Yes,
number 2. no?
let the affidavits come on record after which we
Please.
can
Yes,
proceed.
yes.
Either, yes, for whatever. it
No,
is
your
worth.
lordships have already protected everybody's interest.
For
the last
whatever it
occasion.
is worth, let that
Yes.
affidavit come on record. Yes. Learned,
Additional
My lord, there is an
advantage.
interim
General
order
seeks
connected
time.
scheme.
to place the affidavit on record as directed by this court. On
Court
so
of
and so. List, when do you want it?
Anytime, your lordship.
First week, my lord,
First week, my lord.
Week,
or second week.
second week.
Second week.
Much obliged. I'm sorry, my lord.
My lord, there is an interim order in the connected matter filed by K.
Yes,
Picked up
the
in
interim
your
order
lordship.
is
Connected
enforced,
matter,
will remain enforced till next date of year.
interim order for connected matter to be extended kindly, my lord.
Grateful.
Yes.
That is government advocate.
Same, my lord. Very, very. Thank you.
There was a direction to affect the kata. Mutation of revenue increase was directed to be affected, my lord. In respect of 4 acres, of course, subject to the entitlement of appellant and respondent number 3.
Tahsildar is present, my lord, to that effect. You will give explanation why you could not affect the interim order passed by the court, my lord.
Yes.
Is the Tahsildar Chintamani
What exactly was the interim order? The last interim order?
to affect the name of the respondent in
State submits that further steps pursuant to the order dated 29/10/24 will be taken. In case the order
From the
dated
order.
29/10 is not complied,
May I make my submission?
Tahsildar will appear. What is the 29/10 order?
May I make one submission, my lord?
Just one
In
minute,
pursuance-
please.
In pursuance of a decree in the appeal, my lord,
Just 1
The-
minute, please. Interim order is vacated. Appellant shall comply with directions of the learned single judge subject to any orders to be passed in the RSA. Yes, RSA, are there any orders?
No, my lord, it will be released by tomorrow or Thursday, my lord. We have moved a memo before the concerned judge. No interim order. No interim order till.
That is the question we asked. Is there an interim order?
No, my lord.
Yes. So
So the difficulty
why was the order dated 29/10 not complied with?
in mutating his name is, my lord, no grant file is available in the office. First thing. Second one, the Sagoli chit is not issued by the Taluk office. So we could not mutate the name of the.
ultimately there was a direction to effect the mutation
Whether
subject to the
defendant
result of second appeal, my lord. There was no impediment for the Tahsildar to give effect to the direction.
Either forged concordant document answering the issue in favor of the claimant is so and so. Subsequently, memo dated 5/1/22, seeking disposal, the petition is allowed. Answering the claimant, the first appellate court has permanently restrained respondent state government and the Tahsildar and anybody claiming under them from interfering with the possession.
Please, my lord.
That was the
Order.
protection. You don't have a stay.
No, ma'am.
Why is it not implemented till now?
Because no grant file is available in the.
What
File
you are
of-
saying is in contempt.
No, my lord.
What you are saying is in contempt.
We'll send up the order, the High Court order, the Tahsildar cannot implement the order passed by this because the order passed by the Sessions Court and above, the DC has to take the action, my lord. We'll send a proposal to the DC once
Why didn't you do it till now?
to give that
What was he
effect.
doing till now?
We are in back of the RSA, my lord.
No,
RSA by this weekend.
29/10 is the interim order. Please see the earlier order which is subject matter.
Interim order vacated.
Decree is dated 31/8/2021, right? Decree dated 31/8/2021.
Yes, ma'am.
Is that correct?
Yes, my lord. Yes.
Yes. What was he doing till now?
We filed our appeal and
And
there was a stay in this writ of.
where is the stay?
So, later on it was vacated, my lord.
When was it vacated? When was the stay vacated? Yes, when was the interim order vacated?
October.
Sleeping over the degree, the orders of the court.
After which there was an order on 29/10/2024. After that, what did he do?
2 weeks time, we will send a proposal to the DC, my lord.
Not,
2
nothing,
weeks.
absolutely nothing.
There was no.
This is between the court and the contemner. This is in contempt, counsel,
Yes, my lord.
clearly in contempt. There is an order
Yes, ma'am.
which
Within two-
specifically considered all the contentions and
Within
says
two-
that it must be given effect
Within 2 weeks, we will effect, my lord.
within
2 weeks.
the day. We'll give you time till evening today
No.
and list this tomorrow.
2 weeks. My lord. We have to send a proposal to the deputy commissioner to that effect.
Absolutely not. Anybody, otherwise, whoever is the person responsible to do it will also be present here.
At least 1 week, next Monday, my lord. Next Monday.
You should have done it on 31/8, it should have been done.
Yes.
After 31/8, then again, when this court ordered, that is on 31st January 2022. Again, you should have done. Not done. Then the stay was vacated and this court again ordered. The division bench orders on 29/10. Till now, what were you doing?
27th.
What was the officer doing? If the contention is that it had to go before the DC, why was it not done on 30th, 10/24? What explanation does he have to offer? Do it and report here. No question of 2 weeks.
Just 1 week.
Yes. We list it tomorrow. Tell us what happened.
At least,
Yes.
at least
Yes.
27th or 28th, my lord. 27th or 28th. No.
So, sit here only and see that house.
At least 27th.
29/10 onwards, what has he done? Absolutely nothing. Yes,
One case will explain it so that you will understand the importance of.
he can go straight from here to, we can send him straight from here, no difficulty. After orders being passed one after the other and stay being vacated, this court saying that the stay stands vacated, therefore comply. What do you think? He thinks the orders of the High Court are lower than the Deputy Commissioner's orders. He can think again. Yes, list tomorrow. Tell us what happens by tomorrow and see that the DC complies. Otherwise, the DC will also appear. Yes, list tomorrow.
Tomorrow,
Non-compliance of the directions
2:30.
are noted.
tomorrow,
Listed.
tomorrow 2:30, my lord.
Let him start writing from here. Don't. How is he?
He should have known at least when the matter was listed today. Yes. Tomorrow.
14, submit as.
For the appellant, my lords, this is the KPID attachment. I'm handing over the DD for the principal amount, my lords, and also, my lords, I'm submitting a memo for having deposited those 2 lakh odd towards GST. My lords. May I just? I've handed over the DD and the copies of the GST. My lords may kindly see the DD is for an amount of 67,07,633 and the remaining 2,20,376 I have deposited through GST, my lords. The relevant pages are 44 and 45.
Just a moment. 67,076,3.
Out of 69 lakh 28,009, 67 lakhs 7,633 I have deposited, my lords.
This is
And
correct. You've made the.
my lords, that is
Check
why
the
I produced the
arithmetic.
GST also, my
Yes.
lords. What is
No,
the?
we're just asking you as counsel, you've made,
I made.
you've checked that the arithmetic is
Please,
correct.
my lords, please.
Yes, we'll take that. We'll
Yes.
take this on record.
Please, my lord. And stay may be granted, my lords.
Total is
69 lakh 28,009, my lords. 68,928,009. 67,07,633 is the DD amount, my lords, and 2,20,376 is the GST.
Page number?
Page numbers 44 and 45, my lords. There, in the middle of the page, my lords, 44, J2108, there are specific entries because in respect of all the flats we have deposited, my lords, therefore GST. It is, my lords may kindly note, J2108, that is in the middle of the page, my lords.
108, yes.
J2108, and the last but one entry, J2609, the last but one entry on that page in 44, my lords.
Yes.
And then 45, on 45, my lords, J2809,
Yes,
and below that, my lords, J2909. These are the 4 flats, my lords, for which GST is deposited for 2 lakh amount.
yes.
I had sought for stay of the order. Stay may be granted, my lords.
Respondent party today. Today demand draft dated dash dash. Further submitted that the appellant is paid. Based upon which GST of sum of rupees 2,20,376. We have this submission and handing over the demand draft to the competent authority. We are of the considered view that the matter requires deeper consideration. Hence, there shall be an interim order of stay of the
Dated 7/11 minutes.
order of the special court dated 7/11/24 passed in miscellaneous number 706 of 24. Insofar as
Scheduled properties, my lords, because it is only one
insofar as scheduled properties.
scheduled property.
This is ordered.
Public option.
Notice is not ordered for the private respondents, my
Maybe.
lords. Private respondents R2 to R10 notice is yet to be ordered, my lords.
To notice to other respondents. Call for.
Right. My lords, may I also request that the writ petition be clubbed along with this, because now, my lords, I challenge certain procedural aspects. So
See that. See that.
please, my lords. I'm
Great.
grateful.
Yes.
The DD I have submitted, that may be taken on record, my lords.
Recorded you have to. Then also for the competent authority. Acknowledges the receipt of the demand. Sign ಮಾಡ್ಬಿಡ್ತಾರೆ.
Please.
Yes.
Please, my lords, grateful.
J. Prashad.
On behalf of the petitioner, my lord. Lord, in this case, it had come up on Friday. The lordship direct me to clarify the position. My learned friend, he produced a document before this honorable court. That was on, the document is dated 25/10/2024. My lord, this was impugned in a writ petition earlier, my lord, in 25166, my lord. The lordship will kindly see, my lord. I have annexed it as annexure B, my lord. It was impugned and at page 53 of my writ petition. Page 53, prayer D, my lord. Your lordship got it, my lord? The same annexure, issue or writ or direction, nature of certiorari or other order, this honorable court may deem fit to quash executive order number so and so. It has to be 2510, my lord, but it has been typed as 510. This is the same annexure. Thereafter, the next page also. This was impugned, my lord. The very same annexure, my lord. At page 57 also, your lordship may, it is evident that it was impugned in the earlier round of writ petition. Page 57, my lord. Page 57, your lordship got it, my lord? Then at para 6, my lord, at page 57. May I read it, my lord?
Yes.
Though much arguments have been advanced, taking into consideration that the shifting of the date for qualification from 30th March to 31st July is one time attempt by the state in order to try to fill up all the vacancies numbering to 349. The state were directed to try and work out a solution after discussing all the stakeholders, including the petitioners. Then a memo was filed by the government. That was accepted by the Honorable Court. Your Lordship will get the proposal at page 58.
Here is the adjudication. Said proposal has been made by the state in order to try and resolve. Said proposal by the state is acceptable to all the petitioners in each of the matters.
And it was disposed of.
It's that the said proposal will be applicable only for this year and not for any other selection process. Respective counsel
So the
for the
improved
petitioners
notification-
after conferring with their.
There what
they've
happened,
Accepted the proposal.
my learned friend was appearing throughout in these batch of writ petitions.
He's not signing the point case.
ಅಲ್ಲ ಇಲ್ಲಿ ಅದು ಗೊತ್ತಿಲ್ಲ ನನ್ನ ಮೆಮೊನ ನೋಡಿಲ್ಲ.
No
But
petition stand this.
thereafter, on an application made by one of the petitioners advocates, the Lordship may kindly see, in the memo I produced it, my lord. One memo I filed it on Saturday. It is before this honorable court, my lord.
How's case will be-
It's page 5 of my memo, my lord.
Hmm. Hmm.
Page 5 of my memo, my lord.
Hmm.
That is dated 26/11/24. For Justice Suraj Gondra's order, my lord. May I read it, my lord?
Hmm.
The second para. A perusal of the order dated 19/11/24 and also the unnumbered bullet number 5 of the proposal submitted by the state dated 15/11 indicates that the candidates who have fulfilled the criteria of 1 year of regular service and completion and successful completion of the probationary period, thus totaling a minimum of 3 years as on 31/7/24 would be considered. That would necessarily imply that it is both the probationary period and the service period which has to be taken into consideration for arriving at the minimum of 3 years as on 31/7/24. In other words, all those persons who have completed 3 years of service from the date of joining, so long as they have successfully completed probationary period as on 31/7/24, would be entitled to be considered. My lord, as on 31/7/24, my lord, I must have completed from the date of joining, my lord. Your lordship may kindly see my probationary declaration
When is
order.
your date of joining?
My lord, my date of joining is
9/6/21.
9/6/21. Your lordship will get it at document number 1, my lord, in the same memo, page 3. Page 3, David. Lord, page 3. Your lordship may kindly see page 3. Nine 6/21, my lord, is the date of joining. Kayam Purva Sevege Serida Dinanka. On 21/11, he completes it. Three years is 9/6/24.
But regular service of 1 year is not added to this.
No. Including regular service of 1 year. That is what the order, Suraj Govindra's order says, my lord, which I read it to your lordship. From the date, it has to be 3 years from the date of joining.
Not complete on.
No, from 9/6/21 to 9/6/24, my lord, 3 years it is completed. The cutoff date is 31/7/24.
My lord, his probationary
My
period
lord,
has been-
in fact,
Provided the probationary period is
Has been
completed within
completed.
31/7/20.
yes,
This
yes.
is not done.
It's not been done, my lord. It's been extended to 21/11/23. And his successful completion date is 21/11/23. As per
Even-
21/11/23.
My lord, the order says
His probationary period
3
successfully.
years from the date of joining. The earlier order says 3 years from the date of joining, my lord.
There is an interim order, perusal of order dated 19.
My lord, it was passed after the interim order
As
has been.
also the unnumbered bullet number 5 of the proposal submitted on 15/11 indicates that the candidate who have fulfilled criterion of 1 year regular service and successful completion of probationary period, thus a total of minimum of 3 years. What is the bullet point 5? Is it?
Page 58.
Hmm. 1 year of regular service and successful completion of probationary period, thus totaling a minimum of 3 years as on 31/7. What does that mean?
So from date of,
Who remain after, the second option to select among those seats which remain after selection of the seats by candidates who have qualified as on 31/3/24.
My lord, minimum they need 3 years, my lord. Successful completion, my lord, probationary period is minimum of 2 years.
Correct.
My lord, after successful completion, whatever that period may be, they have to put in 1 year of regular
That's not
service. My
what
lord.
your point number 5 says.
My lord, my lord,
Page
it says
58.
the candidates who have fulfilled the criteria of 1 year of regular service and successful completion of the probationary period, thus totaling a minimum of 3 years. It's a minimum of 3 years.
Minimum of 3 years
And
as
max-
on
31/7/24
31/7/24 shall have the second option to
Please.
select those seats which remain after selection of the seats by candidates who have qualified as on
As on 31/3.
31/3/20.
My lord, there were 2 batches of candidates.
Correct. We understand all that.
Please, my lord.
The question is only this. Have you, as a matter of fact, by this fifth bullet point, which has been accepted by all concerned, have you reduced the requirement that there must be successful completion of probation and 1 year?
My
By
lord,
saying that minimum 3 years, and within the 3 years, successful completion of probation should also happen. Is that the
no,
meaning
that
of
is not the meaning.
bullet point? That appears to be how this court has understood it.
My lord, even assuming that for the sake of arguments, my lord, is the case, my lord,
Hmm.
if they've completed 3 years,
Hmm.
he's not filed his application on time.
Hmm.
Now, my lord, there is decategorization.
Hmm.
So he cannot claim the quota, my lord. As my lordships are aware that there are many matters which are pending today itself.
No, we are not on the
Yes.
question of decategorization or not. Is he entitled to apply is the only
My
question.
lord, my lord, since he is not applied within the time,
When was the time?
his my lord, the time as specified, my lord, is 22/1/11/24.
22/11/24.
Please, ma'am.
Where do you say that he has not applied within time?
Lord, his date of application, my lord, he himself has filed it.
Hmm.
It's on 10/1/25.
10/1/25 is the representation.
10/1/25, because it is only after the reduction that he could have
Please.
applied.
Yes. My lord, one more submission may I make. My lord, in Annexure A,
Hmm.
your lordship will kindly see at internal page 18.
Hmm.
My lord, here, candidates who have completed probationary period, declaration date, your lordship will kindly get one column, my lord. 8th column. my lord.
Yes.
Probationary period declaration date.
Hmm.
There are several candidates. Your lordship may kindly see candidate number 2, Mr. Dr. Mahalakshmi.
Hmm.
She completes it on 21/11/23.
Hmm.
The next candidate
Hmm.
at seal number 4.
Hmm.
She completes it on 21/11/23.
Next candidate.
Next
completed
candidate,
31
my lord, at seal number 4, my lord.
Shripad,
Shripad, yes, Sabnis,
non.
21/11/23.
Non-Kalyan Karnataka GM, 21/11/23.
Likewise, my lord, at seal number 8. This candidate completes it on 21/11/23.
But this is when completion minimum 3 years of service as on
Quite right, my lord.
31/7/2024 is by persons who had the percentile originally.
Please,
So they were included in the list. You
they came to
could
this
have, you could have applied only when the
after the
percentile was reduced.
reduced.
So once the percentile is reduced, there's
Please.
no in-service quota at all.
No, no.
Therefore,
This list has been prepared for 50 candidates, my lord, for the in-service quota, my lord. This for the
correct.
your lordship can kindly see
The
the heading, my lord.
candidates who were eligible and qualified to apply
Please,
as on the as by the norms that were available then.
quite right.
On 6/1, it is notified that the percentile is reduced.
Reduced, please,
It is only on 10/1/2025 when the percentile is reduced that you have a right.
please.
By that time, their contention is that there is no in-service quota available.
No, my lord, this list
It
has
is
been prepared.
already decategorized.
My lord, this list has been prepared for the remaining 50 seats, my lord. Your lordship can kindly see provisional
Where
list
does
of
it show all that?
my lord, page 18, my lord. In a provisional list
Where
of
is the date of this list?
it is 18/2/25.
18/2/25.
10/1/25 is my objection.
Representation, my lord.
But these people also.
May I
only
make
have
one
10th
submission?
percentile, 15th percentile. These
May I-
persons also have only.
Please, my lord. So what I'm gathering,
What is the percentile that they have?
my lord, they've also gotten because of the reduction of
Reduction
percentage,
of-
what I gather.
Huh.
My lord, we don't have any objection in them going through,
Huh.
but they can only participate in the general quota, my lord. There is no quota as such. As
No, no.
it is
This is for-
decategorized.
This list is for in-service
This is just
candidates,
a
my lord.
list of those doctors, in-service doctors whom we have sent.
Hmm.
I'll request them to add their name also and send it across. They can participate in the general quota, not in
That is
the,
what I'm
That is all
seeking.
they want.
that's, that I
That's all
think,
they want. If persons who are similarly situated have been added in this list.
Lord, it appears to be.
His
Who
name
are in
also
lesser-
has to be added. That's all they want.
Please,
Candidates
it
who are
appears to
lesser-
be.
In fact, my lord, candidates who have got lesser merit, my lord, they have been
Correct.
included in the list.
Correct.
I only request is, my lord, let there be an order, my lord.
Yes.
I'll ensure that it will be.
Of course,
Please.
heard the learned, the
Lord, the,
petitioner and the learned, no, not as a quota, learned.
my lord, the
counsel for
option
the
entry, my lord, is today.
Respondent, state. It is submitted by the learned counsel for the petitioner, that the petitioner has
The dear one, sir.
been rendered eligible to participate
In the option entry, my lord.
in the counseling,
Lord, it is
For-
option entry from,
in the, what is it, stray vacancy round?
David,
In the stray vacancy round of counseling for PG medical seats. And that persons who have lower percentile of marks have been included in the list sent by the government
to the KA.
for participation in the in the stray vacancy round. It is submitted that the petitioner is a non-Kalyan Karnataka general merit candidate or
Is-
OBC candidate,
No, my lord.
OBC.
OBC.
General candidate, my lord.
Is a non-Kalyan
Careful, careful.
Karnataka general merit candidate.
Hmm.
And that in view of the fact that persons who have lower merit and lower ranking in the NEET PG examination conducted for the current selection have been permitted to participate in the stray vacancy round as evidenced by
Annexure A, my lord,
Annexure A
dated 18/1/25.
dated
18/2.
18/2/2025. The name of the petitioner may also be forwarded by the government for participation in the stray vacancy round. Though the learned counsel for the respondent submits petitioner points out that there are several persons who have completed probation in the list for participation in the stray vacancy round of counseling for PG medical admission,
In service.
especially in view of, not in any quota, especially in
Lord, it is
view
in
of
service quota.
the proposal which has been recorded in WPC number
In service.
25166 of 2024 and connected cases at bullet point number 5. Full stop. There will accordingly be a direction to the, who has to be directed?
My lord, in fact, KA was not made a party, my lord. I'm filing a memo to include them.
There'll be a direction to the second respondent to include the name of
Yes,
the writ petitioner in annexure A list for participation in the stray vacancy round of counseling to be conducted by the KE. Necessary will be done.
Lord, may I request 3, 4 and 5.
3, 4
Respondents
and
number
5.
3, 4 and 5. My lord, this will be done by tomorrow.
3, 4 and 5 forthwith.
My lord, today is the counseling. My lord, in
To
fact,
be
I
ordered
have been
today itself.
permitted to implement the KEA, my lord. My lord, that it is appearing. The Ramesh, my lord. Because the verification of the document.
Send it, I'll do it.
Yes, it has been
Lord,
to be
I'll-
done by you. We've said forthwith. We'll upload this today itself. Please do the
Please,
necessary.
I'll do that.
The learned government advocate is requested to inform respondents 3, 4 and 5 of the orders of this court and do the necessary at the earliest,
My lord, the KEA.
as well as the KE.
My lord, I may be permitted to implement, my lord. KEA, my lord. My lord, let them be made a necessary party.
Issue direction to KE also.
Allah, immediately party, I will implement them, my lord. Right
You are here. And serve the copies now itself.
I've served a copy.
Yes.
Served a
yes.
copy.
Pleading petition.
My lord, let there be a
Heard
direction.
both sides allowed. Yes,
Lord, let there be a direction to implement KEA, my lord.
yes, we have directed.
Lord, memo be
Please.
taken on record.
Yes, memos taken on record, heard both sides, memos allowed. Yes,
Please,
please do the amendment immediately.
immediately I'll do.
Yes,
Lord, memo for hand delivery.
We upload.
memo for hand delivery is accepted. Yes,
ಮಾಡ್ಬಿಡು ಈಗಲೇ.
B group. As, this is as an interim order, not disposed, it is as an interim order, let it go as an interim order. And then we'll dispose it off after the, otherwise there may be some delay.
Today is the counseling.
May I
Work.
request, my lords, to post it on 11th, my lord, 27th, my lord, orders, so that
Yes,
everything will be
can
done by
closed on that. Yes.
Please.
Let this be done at the earliest, please. Would we have to upload it at least in the afternoon?
B group, number
Or
60,
somebody else.
Akma Devi Hireman.
The matter where the virtual seats were not being notified. The Lord remembers that in the one round, if they surrender the seat, they are not notified in the next round. So we had kept this matter by so that for the next year, we could issue certain direction. Let this round be over, all this, so it may be called after about a week,
Please, my
and then we can issue. the-
Appears they have
Done it.
displayed a
Everything.
list, my lord. I'll just subject to my
Please.
verification. I'll take notice tomorrow.
Yes.
lord. Record or not.
Notice is ordered. Can we have this next week?
Please, my lord.
In the meanwhile, the counseling will also be over. If there's any problem, then we can be notified.
In fact, the
Yes.
council on record has some difficulty. She's not here today. So it would be,
Next
we'd be
week.
grateful if it's taken up
5-3.
next week. Please.
17,
17.
Yeah, please. In this case, my lord, since the pleading stated that, my lord, the earlier submissions was oral submissions is what has been pleaded by the petitioner. The submissions of the MCC was oral submissions. Therefore, my submission is this, my lord. Your lordship may pass it over. I'll put it on recording by 2:30.
Also,
My lords, counseling is, they have already started. That should not come to an end, my lords. Lords, because I have,
list this, pass it over. Let's see. Yes,
In this case, my learned friend, friends, my lord, this matter is already covered by your lordship's judgment. That is 4723, my lord.
you're aware of it? Yes, pass over.
my
order.
lords, if they can give me their statement, my lords, early, by 2:30, I will be in a position to make my submissions, my lords.
Orders, number 18, KC Pratik.
Nothing more appearing for almost 5 years. They are not filing paper books also, and they are not coming with this on the paper.
713 of 2014. 18. The sheet. Steps have not been taken. None appears 16, 12, 19. What is this? First time is very good. Then let's. Pass orders.
Must provide time to find on 10/3, 28/8. On 28/1, pass the following order. Okay, matter is called out. Appears the element is not.
Appeal has already been dismissed as against R2 on 16/12/2019.
We also notice that they ordered to do 16/12.
Yes.
Withdraw. 20, HT Nataraj, dismiss as withdrawn.
20 partition suit 2015.
Kindly see the one and two, the serial of item number 1 and 2, the regarding await of notice. And second is the steps to be taken. Then we have complied all the 3, 4, 5, 6. We have taken steps.
The names 8, 9, 13. 7, 44, 48. Called out.
Shankar, P. Malkonda Reddy, Subramanya Reddy, Dilip Kamath, Rajshekar, Anil Kumar, Rekha D. Kamath, Ramchandra, P. Subbareddy, Rajesh, Dr. Albin Sikabani, J. Srinivas, K. Elangavan, CH Subraju, Arun George.
16, 17, 40.
16, 17 and 46 in Andhra. In item number 1 and 2, we will take regarding R11 A to C and R3. I will take.
Wait.
Not taking a steps to R3.
R3 I will take because of some address here. Now I have available. So we can.
ಅಬೇಟ್ ಆಗತ್ತೆ ಅಲ್ಲ
ಅಲ್ಲ R3 ಗೆ ಈಗ ತಗೊಳ್ತೀನಿ ಈಗ ಅಡ್ರೆಸ್ ಗಳೆಲ್ಲ ಬಂದಿದೆ
2 ವರ್ಷ ಆಯ್ತು 2-3 ಸತಿ ಕೊಟ್ಟಿದ್ದೀವಿ
1 week
ಏನ್ ಹೇಳಲ್ಲ ಏನ್ ಮಾಡ್ತೀರಾ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಆಗತ್ತೆ ಅಬೇಟ್ ಆಗತ್ತೆ
I will take necessary
21, B. Pramod. 2009. Steps.
This is that matter. That's to be correct.
Saying that how do you protect the interest of the allotee? We are protecting the allotment as well as what we have filed a on the ground that
Then how can?
Nothing remains in the writ petition.
That's it.
If they are giving alternative sides, we have no objection. Let me go through this.
We are not between you and you. Pains goes.
Let me.
This is no finality for
No,
public.
there, just in case you succeed in the review, you get the land.
Yes.
That's all there is to it. Give him the alternate land and we'll leave open the review.
Yes. Alternative site, but where exactly they have to mention. And same similar, but
civic community. So far as the general allotments are concerned, for them we have an alternate lot. That is why
But the,
for civic community sites, there are no rules of alternate allotment.
but the,
At the end, we'll have to refund the money if we have collected any amount from him, and he'll have to again participate in a fresh allotment process, then he'll get succeed. That is how.
But we have-
But however, we have said that the fact that the facts were not brought in for the court, not we filed a review.
Now, which is the site that you're seeking to allot?
Not, we have not proposed anything.
yes,
So
no,
as
they
of-
have to
as of
propose
now,
the side, my lord,
today
the
we are
question is.
As of today.
Degree, ಯಾವ್ದಾದ್ರು ಇದೆ ತೋರ್ಸಿ. District ಅಲ್ಲಿ ತೆಗೀರಿ.
We also have certain constraints. 2003, Lord, we allowed him a site of an alternate. But here, Lord, I should not be arguing for against him, Lord, my own allotting, Lord. When it comes in between us, Lord, we'll be able to argue that. Lord. I don't want to argue that. So the fact that 2003, we allowed him an allotment site is given. But 2008, till 2018 also, nothing has been proceeded further. But in fact, the possession was given to them. Possession is compounded. Everything was there. Lord, in fact, we failed to bring it to the notice of this court. Lord, it is now, Lord, since we have failed, I don't want to put a burden on them and say that, Lord, they is not good. But if we have also already filed a review.
Either way, that you don't bring things to notice of court
one
is
thing-
nobody's fault.
By 3 weeks, Lord, by
They
then-
come with options, how many CS sites are there?
Yes.
They will
Lord,
choose.
yes, yes. Lord, we
But-
adjust this matter by 3 weeks. Lord, by then, Lord, things will,
3 decades also will not solve.
But shall I make one submission, my lord?
Lay case.
Ashim may kindly say, the lease was executed on 8/1/2005. And my lord, the possession was given to us. Khata was transferred.
no.
Land was sanctioned in 2005.
That has to be sent to the pending branch with the other file. Yes, sorry.
Plan was sanctioned in 2005 itself. You have put up the basement. Building has come up to a certain level. Then my lord, all these things have taken place. Filed petition, they have not contested. They,
Damages for all these things.
my lord, we have spent more than 3.5 crores, my lord, we have
that's why
spent.
we have said we'll give them an alternate site, subject to.
Which is that
in
alternate
this-
side?
Yes.
Lord, Adana,
Giving that allotment letter.
Lord, what they say,
No, no. Which layout, sir? This is CS site was allotted?
Pardon, my lord.
CS site.
JP Nagar
which layout?
stage.
This is JP Nagar 7th Street.
This near airport, some sites. will- you have to give that one now. They will take.
the Japanese 8 stage. It is not
Yes,
first one
it is
matter,
seventh.
Lord, our review will not be a one matter, there will be 75 matters which are pending before the Honorable Supreme Court pertaining to the very same layout. But this will be heard together, and Lord, will have some bearing, Lord, he'll also get some benefit out of it. Lord, you may have it after 3 weeks.
In the meanwhile, please file a proper affidavit.
But at least let them identify which side they are going, how
Yes.
many sides are available.
Yes, we can't just simply adjourn it for no reason.
Same dimension, when you will issue allotment letter, when you will execute the lease of select. That affidavit will. This affidavit will go.
Where?
One affidavit to say that from BD office to High Court we are reaching, another from here to Canton.
Twen-
It's a site.
20 years are over, 3 crores, that time you have invested. my lord.
We are aware of what normally happens in review petitions also. Now, if you succeed in the review, you get the prime site. You can allot it as a civic amenity site thereafter at today's rates. No difficulty.
Let them give list of alternate, let them give the list of sites, what are the available. So that, my lord, if suppose, my lord, my site is, if they are, I don't mind paying extra money also, my lord, suppose they have allotted 3,825 square meters of land. That comes to 41,157 square feet to establish education institution. And we have taken all the permission. Then, my lord, if they want more than extra, more than this area is available, We are ready to pay the present value. We don't, we are not shirking from that, more than that value. And ultimately, we want to establish an education institution.
You
for
win both ways. If you win in the review petition, you get the property, which you can further allot at whatever is the current rate. No harm.
And our investment
All in
itself
public
is
interest.
3 crores that time. Basement, everything has been done. I produced the photographs. Yeah, but I am told
Please
there
tell.
are,
Yes.
but I am told there are several sites are available, civic community sites in different layouts.
Please inform
Let
us
them find out
what
and give
sites
to
are
the- give to
available
the
and
council.
what you intend to do.
Along with the objection, they have filed some list also. Let them find, identify and give to us. We are ready to take it and close this. Puraki.
Next site. Civic community site in the said activities based on the file. However, the affidavit does not indicate that, indicate the site number, timeline within which the allotment should be made. Council for the VDS admits that the allotment would be considered only after the disposal of the defined by the VDA for the Supreme Court. Such a condition, they are not agreeable to stop. At this stage, the council for the BDA seeks 2 weeks time, 5 better affidavit indicating 2 weeks time to stop. You have the said where list on so and so. It is made clear that BDA shall file affidavit indicating the timeline within which the CS site of the same dimension would be allotted in favor of the petitioner and the particulars of the site.
Same or more. And the same, more means we are ready to pay excess amount also. We don't mind, man.
Indicating the timeline in which a civic community site will be allotted in favor of the petitioner. Based on so and so.
Please identify the site also by that.
Interim order may kindly be used. Interim order may.
Order clear that finish, continue. Till next day. Please start.
And
Please start.
plus may kindly post further orders.
14-3.
No, otherwise,
That may create a problem.
22.
This much it has come.
ಆಗಲ್ಲ ಬಟ್ ಮತ್ತೆ ಹಸ್ತಾಕ್ಷರ ನೋಡ್ಬೇಕಲ್ಲ ಅಂತ ಅಷ್ಟ ಮತ್ತೇನಿಲ್ಲ ನಥಿಂಗ್
Lord, I appear for the appellant. Lord, I have complied the office objection on the last week itself, my lord, before last week. I don't know again why they have raised this.
Because your order has not been recalled.
But that order has been recalled on 20th January 2024, my lord. All that I'm asking this, my lord, the penalty which has been coming in the learner single judge be waived out because my lord, the appellant has already surrendered the site.
So 2 office objections are there. Jagdish.
This prediction is not proper.
Mr. Jagdish. You
If
have
that
served-
were to be so, comply ಮಾಡಿದೆ ಸ್ವಾಮಿ ನಾನೇ ಬಂದು ಅಲ್ಲಿ ಫಿಸಿಕಲ್ ಆಗಿ.
serve the appeal memo on the AGA. Is the first office objection.
But I have said it, my lord. I got investment also. AGS appeared on the last occasion, my lord, on January when the IA was recalled.
ಇದೇನ್ರಿ writ appeal.
Sir.
It is submitted that the memorandum of appeal is served on learned AG in view of the said submission of his objection. One is overruled. Verifying affidavit and annexure to be filed by the respondent to be furnished, if any. Whether they have filed objection, sir, you have to furnish that objection before the single judge.
Objection file Madila Swami. They have
Huh?
not filed.
Uh,
They have not
counsel-
filed it, my lord.
Appellant submits that the response have not filed any objection before the single judge in view of the said submission. Office objection number 2 is overruled. List for admission.
Obliged, my lord.
Twenty-four, Vinod Kumar BN.
Lordship, I appeal for appellants. The second set has to be filed. I will file by today itself, my lordship. And in the meantime, I'm being permitted to comply the main office objection, recalling dismissed for.
The appellant is permitted to.
Please. Great.
25 adjourned, 26.
My lord, appearing for the appellant in this case, my lord, senior counsel is on the way. Meanwhile, senior counsel suggested that if it can be referred to mediation with the approval of the other side.
I will instruction only carefully mediation ಏನು ಆರ್ಡರ್ ಏನು mediation ಹೇಳಿ ಹೇಳ್ತೀನಿ ಹೇಳಿ ಹೇಳ್ತೀರಾ ಯಾವಾಗ ಹೇಳಿ ಪಾಸ್ ಕೊಡಿ ಅದಕ್ಕೆ
27.
My lord, I appear for appellant in this matter, my lord. The connected matters are posted on 12/3, my lord. And this property attached with the school, my lord, wherein 500 students are.
Please comply with the office objections, please.
I'll do it, my lord.
How many office
12/3
objections
connect.
are there?
12/3 other connected matters are posted, my lord.
Please comply with the office objections first.
I will comply. 12/3 other connected matters are posted, my lord. It may kindly be posted on the same day.
28. Akma Devi Hina.
Appear for petitioners, my lords, in serial number 28.1, my lords. My lords, serial number 28.1 and serial number 28.5, my lords, are a different issue, my lords.
What is the difference in the issue?
My lords, in 28.1 and 28.5, the challenge is to the executive order by which, my lords, the rules was amended. My lords, if my lords takes 28.1, my lords.
Yes, essential contention is decategorization of the in-service seats which are available for PG medical admissions. The right of the petitioner was in service. Yes. Yes.
My lords, in 28.1. My lords,
Just 1 minute. 28, who appears? Item 28 has become infructuous. That already is been.
These matters are covered by your lordship decision. Now, my lord, they want the mop-up round to be redone. That cannot be done at this juncture.
Hmm.
If they have any grievance about against the government, my lord, the order, that only could be done, my lord, for the next academic year, not now. They allowed everything to go on, my lord. At this juncture, they want to upset the whole.
Yes. How do you come into the picture at all?
I'll show it. It is not so.
You come into the picture by the lowering of the
Yes, yes.
standards,
That
all
is-
of them.
My lords, that is
It
permitted.
is also by an executive order.
No, my lords, that is permitted under the brochure.
Hmm.
I'll show it, my lords. If my lords permit in 28.1, I'll show it.
Hmm.
My lords, in 28.1, my lords, the prayer
Hmm.
first prayer was, my lords, for consideration of representations, my lords, for reduction of the percentile,
Hmm.
which now does not survive for consideration because there is a reduction of percentile.
Hmm.
The other prayer, my lords, prayer number C,
Hmm.
was challenging the, my lords, executive order, which is at annexure F,
Hmm.
by which, my lords, the rules came to be amended.
Hmm.
Rules provided, my lords, 31st March as the cutoff date
Hmm.
for, my lords, candidate to be eligible to apply for the examination.
Hmm.
The executive order comes to be passed, which is at annexure F, by which that 31st March date is extended to 31st.
Already approved by the learned single judge. If
No,
that
my
is
lord,
the
it was
contention, that
before
stands
the-
approved.
No, my lord.
Yes,
That was argued in serial numbers
yes,
15.
31/7, 24,
24.
that has been approved by the learned
It
single
is,
judge.
it is not approved by the. Can they amend the rules?
Hmm.
That is the first issue before my lords.
Hmm.
My lords, the rules is the executive order is to annexure F, page 40. The relevant operative portion is at page 43. My lords, translation is also given, but it is in English, my lords, at page 43 itself. My lords, got it, my lords? Page
Yes.
My lords, in service.
To affect the petitioners who adjourned prior to rules coming into force. Under the circumstances, in the light of the indisputed fact that the state government and director have not taken any steps pursuant to the aforesaid recommendation dated 23/8 regarding extension of cutoff date, that is 31/3, since notification date has already been issued for admission, including petitioners by way of interim arrangement, without prejudice to rights and contentions, state government and the director are directed to take appropriate action to pass appropriate orders and recommendation dated 23/8 on or before 4/10/24. In-service candidates with 1 year of permanent regular service after successful completion of probationary period as on 31st July, in which the entrance test is held, shall be eligible for admission. This is the amendment.
Please, my lords. My
Shall
lord,
be eligible for admission under these rules, eligible to apply for the common entrance test.
my lords, may kindly note two things, my lords.
Conduct of test for so and so, so and so. So and service is completed. 1 year of regular permanent service after successful completion of probationary period as on 31st July shall be eligible. This is an amendment.
My lords, this is my lord, this is my lords pending, my lords approval from the pending amendment, my lords, that was specifically said at page 40, the first paragraph.
What does it say?
The translation, my lords, is at page 47. Lords, at the last paragraph, my lords, page 47. It seems that some serving doctors are allowing those who have rendered 3 years of permanent government service, including the probationary period, to participate in the NEET PG counseling. Considering the said request, it would be possible to provide higher education to a larger number of serving doctors. Pending the amendment to the PG rules, the Directorate of Medical Education has submitted a request to make appropriate amendments through an executive order and to extend the date of assignment for postgraduate studies from March 31st to July 31. Amendment was pending, my lords.
This is not the, it does not appear to be a proper translation.
My lords, page 43.
Yes, please read page 43 and tell us what it means.
My lords, I'll read it Kannada, then I'll.
Yes, please.
ಮೇಲೆ ಓದಲಾದ 2 ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಿದಂತೆ ದ ಕರ್ನಾಟಕ ಸೋ ರೂಲ್ಸ್ ನಿಯಮ 10(1)ಕ್ಕೆ ತಿದ್ದುಪಡಿ ತರುವುದನ್ನು ಬಾಕಿ ಇರಿಸಿ ಈ ಕೆಳಕಂಡ ತಿದ್ದುಪಡಿ ಮಾಡಿ ಕಾರ್ಯಕಾರಿ ಆದೇಶವನ್ನು ಹೊರಡಿಸಲು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. Notes pending, my lords, the amendment approval. An executive order is passed to amend the rules is what they say, my lords.
So what is the amendment that is the proposed amendment?
Please.
The prior paragraph is the proposed amendment.
Please.
Okay.
My lords,
Then has the amendment come through?
no, my lords. No, my lords, may kindly note two things in that amendment, my lords. One is, they say has completed 1 year of permanent regular service. Second thing is, date is changed to 31st of July. Now, my lords, may kindly come to the rules, my lords. It starts at page 71, annexure J1. The relevant rule 10 is at page 81, my lords. Rule 10, my lords, rule 10(1). No in-service candidate shall be eligible for admission under these rules. In-service candidate was completed 5 years of regular employment in service, including successful completion of probationary period, as on the 31st of March, in which entrance test is held, is eligible to apply for the common entrance test. These rules, my lords, came to be amended in 2024 at annexure J3, page 92, my lords. The relevant amendment, my lords, is at serial number 3. At page 92, annexure J3, in-service candidate was completed. My lords, may kindly note, my lords, 3 years of regular service. After the successful completion of probationary period, as on 31st March, in which the entrance test is held, shall be eligible for admission under these rules and is eligible to apply for common entrance test and to participate in the counseling. The amended rules, my lords, as on 2024 said, it has to be 3 years regular service. Second thing, it has to be 31st of March. No, by way of an executive order, my lords, 3 years is reduced to 1 year. 31st March is extended to 31st of July.
3 years is not extended to 1 year, I mean, reduced.
It is, my lords, it is. My lords, may kindly see page 43, my lords.
Just a moment, just a moment. 3 years regular service after the, okay.
Please,
okay.
now in the executive order, it is 1 year. They have reduced it. Now, this is the first moot point before my lords. I'll directly take, my lords, to the one decision of the Honorable Supreme Court.
Now, please tell us one thing. How are you prejudiced?
My lords, my lords, I had also applied, my lords. My lords, may kindly see the brochure of the KEA, my lords.
You had the 50 percentile to apply?
I did not have it, my lords, but my lords, may kindly see the brochure.
So how are you aggrieved by this?
My lords, I am aggrieved because, my lords, subsequently.
By the time you apply, there is no in-service quota. It has already been decategorized. How are you aggrieved? Some other persons are also permitted to participate in the selection process, not in the in-service quota.
Please.
Not in the in-service quota. They are also permitted.
Please.
The field is widened. How are you affected?
My lords,
If you have the required merit, you will still get.
My lords, My submission is that, my lords, this petition was filed in, my lords, on 26th of November before. the
Whenever it
council.
was filed, you
My-
must first tell me how are you affected?
My lords, affected-
You, when you filed the application, you were nowhere in the picture.
Please, my
right.
lords, please.
You became eligible by the reducing of the percentile on 6/1, notified on 6/1/25. Now, where on, as on 6/1/25, there is no in-service quota. There is only your permission to participate in the process. You still have the right to participate in the process. Other persons who probably have better merit than you are also permitted to participate in the process, not in the in-service quota, in the general quota. They will also be considered for admissions.
I
This
understand.
is all
that,
there
my
is to
lords.
it.
I understand. My lords may
Yes.
kindly appreciate this point. What I'm challenging is, my lords, is an executive order. If, my lords, that executive after this court says could not have been.
By a person aggrieved, we can consider
I am aggrieved, my lords.
a challenge.
I'll
You are
show it
not
to- I
aggrieved.
show it to my lords. My
Yes,
lords may
please tell us how you are aggrieved.
kindly see the KA browser, my lords, just filed before this honorable.
Yes.
Because the argument was made, my lords, that the rules of the games have changed. When it applies to them, it has to apply to us also, was the view that this court had taken.
Yes.
That is not so, my lords, because in the brochure, it was already intimated that there could be a reduction in percentile. My lords, if my lords take the e-bulletin, my lords, of the KA, my lords, serial number, clause number 8, my lords, there is a note.
Hmm. Where is the KA bulletin? I mean,
Just-
KA brochure? Have you produced it?
Lords, it was handed over to the court, my lords, on the last date of hearing. I'll give it. Copy then.
It was handed over several times, counsel. Have you
My-
produced it? Have you challenged it?
No, I've not challenged the brochure, my lords, sir.
Yes,
I just give a copy.
where have you produced? Finally, sir.
Madam. I just mark the page number, my lords, for my lords' convenience.
Yes, where is the ground taken in your writ petition?
Is like the ground in the.
I'll just show it.
ಕಡಿಮೆ pages ಇದ್ರೆ ಮುಂದೆ ಜಾಸ್ತಿ ಎರಡೇ page.
It's not- Yes, it's all good. That I've referred to in this. It was- I'll be trying to correct also.
Lords, I violated.
Please not like.
My lords, my lords, this is a subsequent event, my lords, because I have made that amendment, my lords, amendment petition is also filed. Subsequent to this notification on 4/1/2025, my lords, amended application came to be filed, which is allowed by this honorable court, my lords, amendment is done.
What is the amendment?
My lords, amendment, my lords, to challenge the subsequent, my lords, that final PG seats. Which was prepared by the KA, my lords, in terms of this executive order was also challenged, my lords, by way of this amendment.
Even that prayer was not there initially.
Initially, that prayer was not there.
It was
What
not
was
there,
your prayer?
my lords.
Initially, what was your prayer?
Initially, my lords, prayer, my lords,
Consider your representation.
my lords, annex prayer A and B for representation considerations, my lords. Prayer C, my lords, for challenging the executive order. Then prayer D, my lords, for challenging the seat matrix itself, which was preferred in terms of the executive order, my lords. Subsequent amendment was brought, my lords,
Was
when
on 27/11/2024, when you were not even eligible.
I was not even eligible, my lords, but there was pending representations, my lords, before the respondents. Now, my lords, may kindly see the, my lords, the note appended to clause 8 of the KA brochure. I have put a flip, my lords, on.
Yes.
This in-service, my lords, admission was also regulated. The regulations as per Rule 9 of the Medical Council of India, postgraduate medical education regulations 2000 as amended from time to time will be applicable. This was made specifically known, my lords, under the brochure. Lords, I'll place on record, my lords.
The seats within in-service quota shall be reserved as per the MCI, DCI, government issued from, probably government instructions issued from time to time.
Please.
Any seat reserved for in-service candidates which shall remain unfilled for want of eligible candidates or otherwise shall be added to the non-in-service quota as per government DME instructions.
Please.
It is also there.
Please. My lords.
Decategorization is also there. No
No.
challenge.
There's a specific question, my lords, from this honorable court on the last date of hearing, saying when you when you say that there's a change in rules of game in respect of an executive order, when you come into picture, my lords, by way of reduction of percentile, there's a change of rules, so you cannot take that ground. Therefore, I'll place that regulations of MCI, my lords. This view was taken to the coordinate bench of this honorable court, my lords. So my lords was part of the bench. They specifically said, my lords, when the brochure provides, my lords, for the fact that there will be changes in the rules, that will not be applicable, my lords, to contend that there's a change in rules of game.
Service candidate is already holding a postgraduate diploma in any specialty shall be eligible for postgraduate course in any specialty.
My lords, may kindly take
They have
page number 16 of the regulations.
in addition to the above in-service should seats within in-service quota shall be reserved as per MCI, DCI. Government orders issued. Any seats reserved. for in-service shall be- Yes. Just a moment, please.
Page,
Yes,
page 16, my lords.
Hmm.
Rule 9, my lords.
yes, we've seen.
At page 17, relevant is 9.3, my lords. In order to be eligible for admission to postgraduate course for an academic year, it shall be necessary for a candidate to obtain minimum marks of the 50 percentile in the NEET for postgraduate courses held for the said academic year. However, in respect of candidates belonging to scheduled caste, scheduled tribes, and other backward classes, the minimum marks shall be at 40 percentile. In respect of the candidates with benchmark disability specified under the Rights of Persons with Disability Act 2016, the minimum mark shall be at the 45th percentile for general category and 40 percentile for SC, ST, OBC. The percentile shall be determined on the basis of highest marks secured in All India Common Merit List in NEET for postgraduate courses. Now, the proviso, my lords, provided when sufficient number of candidates in the respective categories fail to secure minimum marks as prescribed in NEET held for any academic year for admission to postgraduate process, the central government, in consultation with Medical Council of India, may at its discretion lower the minimum marks required for admission to postgraduate courses for candidates belonging to respective categories, and marks so lowered by the central government shall be applicable for the academic year only.
Yes.
This, my lords, is consonant with the view taken by my lords, this honorable court.
Reservation of seats in medical colleges, institutions for categories shall be as per the applicable laws prevailing in the states union territories. An all India merit list shall, as well as state-wise merit list of eligible candidates shall be prepared on the basis of the marks obtained. No candidates who has failed to obtain minimum eligibility marks as prescribed shall be admitted to any postgraduate course. Non-governmental medical colleges, 50% of the total seats. So. Therefore, it is reservation in medical colleges, institutions. Therefore, all the provisions are there. Yes, all this we have discussed. Yes.
No, this view is not taken, my lords. My lords, may kindly see the coordinate bench.
Do it. Yes.
Coordinate bench decision of this honorable court, my lords.
Yes.
Specific issue was before this court, my lords.
Yes.
Lords, in the case of Dr. Yogendra Jairam, copy was furnished, my lords, on the last date of it.
Yes.
My lords, page number 15 of that order, my lords. Referring to my lords Nipun Tiwari's case, my lords, this court had said, the principal issue before us is whether the government regulation would have to be held not to apply to the current academic year on the ground, which is urged by the applicants, namely that there is a change in the rules governing admission after the admission process has commenced. My lords, I'll skip 26, my lords. 27. The court noted that counseling for admissions to super specialty medical courses was postponed, at which stage the government of Tamil Nadu issued a resolution on 7th November 2020, reserving 50% of the super specialty seats in government medical colleges to in-service candidates. It was in this backdrop that the court observed the process for admission to super specialty medical courses started on 3/8/2020, and it was made clear to all the competing candidates that there shall be no reservation to the super specialty medical courses. The government order issued by the state of Tamil Nadu on so reserving 50% seats for in-service doctors would be detrimental to the interest of the meritorious doctors, as 50% of available seats in the state of Tamil Nadu in super specialty medical courses will not be available to them. Now, my lords, paragraph 30, my lords. Clause 7.2 of the brochure issued by the state government provides that 50% of the seats in the postgraduate diploma courses would be reserved for in-service candidates. Clause 7.2 also provides that for the in-service quota reservation, any change made by the government from time to time will be applicable. This very provision is also there in the bulletin, my lords, in the present case. An additional weightage for the in-service candidates was also prescribed by clause 7.2 in terms of clause 9(4) and 7 of the MCR regulations. Clause 8(16)(1) prescribes that eligibility for in-service candidates would be in terms of the government regulation dated 19 March 2015 or any other government regulations issued from time to time. Incentive marks of up to 10 marks for each year of service in remote or difficult areas subject to a maximum of 30% of the marks obtained in the NEET PG 2002 would be prescribed in clause so and so. Now, my lords, may kindly come to my lords paragraph 32. My lords, and a submission was made that there's a change in the rules of the game. That was negated by the Supreme Court. It is difficult to accept the submission of the appellants that the government resolution dated so and so ought not to apply for the current academic year on the ground that it has altered the rules of the game midstream. The High Court has principally rejected the submission of the appellants on the ground that there was no challenge to the validity of the government regulation dated so and so, in which event it is not permissible for the court to read down so as to exclude its applicability for the current academic year. Now, my lords, 33, my lords, they refer it to the factual scenario, my lords. At page 19, the first paragraph itself, my lords. The provisions in the brochure that in-service quota reservations would avoid by any change made by the government from time to time must be understood in the context of the above facts. The provisions of the brochure specifically place the students on notice that in-service reservations would avoid by such regulations as may be issued by the government from time to time. The issue before us, therefore, has to be construed in specific background of the facts as they pertain to reservation in state of Maharashtra for in-service candidates in postgraduate degree courses. At para 35 minutes, in so and so, this court was faced with a similar set of facts. In that case, the registration for the examination closed on 18th of April 2021. A notice providing reservation for OBC and EWS candidates was issued on 29th July 2021. This notice was challenged on the ground that the rules of the examination could only be changed before the last date of registration for the examination. A two-judge bench of this court, of which one of us, Justice so and so, was a part, ruled that the impugned notice did not alter the rules of the game after the game had begun, because this is relevant, my lords, because the information bulletin in that case specified that the details of the applicable reservation would be notified by the counseling authority through a separate handbook. Thereafter, my lords, this being the case, the candidates who wished to register for the examination were aware that the details regarding the seat matrix reservation would be made available at a later stage. Similarly, in the present case, clause 7.2 of the brochure issued by the state of Maharashtra clearly specifies that the reservation policy for in-service candidates is subject to any changes made by the government from time to time. Hence, the brochure envisages that there may be a change in the reservation policy for in-service candidates and accounts for the same. The rules of the examination have remained constant and the government resolution dated so and so did not change the rules of the game after the administration process has changed. With this, my lords, at para 38, page 21, my lords. The Government of India through the Ministry of Health and Family Welfare has issued a communication on 17th October 2022, providing for a reduction in the cutoff marks in the NEET PG 2022 by 25% across all categories. Following the above decision, it is likely that additional candidates would become eligible to participate in the subsequent rounds of counseling. Moreover, from a reading of clause 7.10 of the brochure, it is apparent that if any seats which have been provided for the in-service quota remain unfilled, they shall be distributed to the non-in-service category of candidates using NEET PG 2022 merit list. With this view, my lords, this court said, in view of the enunciation of the law laid down by the Honorable Supreme Court referred supra, in view of the fact that the respondent authorities have lowered the percentile points or the cutoff marks, the eligible in-service candidates are entitled to participate in the rounds of counseling. This court is of the considered view that the above petition could be disposed of with a direction to respondent number 1 to 3 to decategorize the in-service candidates quota seats to the mop-up round so that the in-service candidates can select their seats during the earlier round of counseling based on their merit. Now, my point of contention before my lords
Categorization, in addition that there are three more not to be.
No, my contention before my lords is this. If my lords,
Categorization had already taken effect. There is power.
yes, yes,
Circular.
my lords, I am not on
voucher.
I specifically make this point clear, my lords. I am not on decategorization, my lords. My petition, serial number 28.1 and 28.5, my lords. My learned friend concurs. It is not on decategorization. I am on the point, my lords, if the executive order is held to be bad.
Yes, we'll continue.
If executive order could not have been passed, my lords, that 60 candidates who have come into picture, my lords, in view of that executive orders, that seat will have to come back. If that comes back, my lords, these petitioners will be entitled to come to the counseling, my lords.
There is no, if the recategorization goes, then you don't have a case claim at all.
But
Yes,
if that executive order, they could not have made.
consider, yes,
Great.
First matter.
yes. 20.
That belongs, it goes against their candidates, my lords, because we became eligible on 31/7/2024. So, my lords, because what has happened, my learned friend has not mentioned before this honorable court that on the first instance, when the amendment was brought in 2024, 24 June, my lords, that was paid by the learned single judge. We're saying that we all were appointed in 2021, and this amendment should not have been applied to you people. That is us. Therefore, my lords, we have completed as on 31 July 2024, we had completed 3 years, including 1 year probation. Therefore, my lords, as far as this petition is concerned, my lords, it does not survive because, but however, my lords, that executive order or even reversing that is going to be again a problem for us. Therefore, my lords, that cannot be considered.
Yes.
Because in the first instance, when the
What was your prayer?
my prayer, my lords, they should have been allowed in the mop-up. That is not done. That also round is over, my lords.
In the remaining government seats in government colleges,
because
government
that
quota seats,
did not
exactly.
happen.
That,
Because-
that covers the other issue.
Yes.
Now, your only problem is that the other two writ petitions, if they are allowed, then
I
you
be
will
in
go
trouble.
on.
And not only that, my lords, those who have been already given seats in the first round were eligible candidates. They also will be in trouble.
Correct.
Because
Yes,
it is a pure question of law, whether
Yes.
it can be applied to us or not.
yes. Yes. Yes,
Your Lordship, appearing for the petition in 28.4.
yes,
Your Lordship, there's a small slight deviation here.
yes.
Now, if you look at the particular aspect, I would like to bring the attention of this honorable bench to
Mm.
the KEA brochure, my lords.
Mm.
My lords, KEA brochure, I'll just bring it to the relevant paragraph.
Yes,
My lords, at page number 41, counseling procedure and allotment logic.
Mm.
My lords, here, the KEA speaks and represents that there is an allotment logic that it will follow.
Mm.
What is the allotment logic? There will be the first round, second round, mop-up round, and stray vacancy round subject to availability of seats. My lords, here, the particular power to exercise decategorization, one should have been done on a consultative basis with the central government.
Mm.
The rules have already been read out before the honorable bench. My lords, further, I would like to bring across the relevant paragraph, which my learned friend reiterated, Dr. Yogendra J. Ram. Your Lordship, the para number 4, it very conclusively says, my lords,
yes.
just read the relevant paragraph. In view of enunciation of the law laid down by the Honorable Supreme Court, and in view of the fact that respondent authorities have lowered the percentile points or cutoff marks, the eligible in-service candidates are entitled to participate in the rounds of counseling. The court is of considered view that the above writ petition could be disposed of with a direction to the respondent number 1 to 3 to decategorize the in-service candidates to the mop-up round so that the in-service candidates can select their seats during the earlier rounds of counseling. My lords, there has been a catena of judgments wherein there has been directions passed to the respondent authorities. They acted in haste, my lords. Here in this year, when the counseling was taking place, my lords, here I am not here on the whether the state government has the power to decategorize or not. Here I am only on the point whether they exercised such power in an arbitrary manner. My lords, here I am trying to show clearly that they acted in an arbitrary manner because time and again, year on year, the percentile has been decreased. And here in this particular instance, before even the first selection rounds comes to a conclusive end or a fruition, they have gone ahead and decategorized the entire in-service quota reservation
defying their own logic, my lords, which is provided at page number 41 of the KEA brochure. My lords,
Yes.
further thereto, I would like to bring across a small clarification before the honorable bench as to whether this particular aspect acts as an incentive or not. My lords, the multiple state governments have different ways of granting benefits to in-service candidates.
Yes.
My lords, in Karnataka, it is not the case of a benefit that is granted, my lords. It is the classification of reservation that is granted. My lords, I would like to bring across a particular decision wherein it was clarified what is the aspect of incentive vis-a-vis reservation. My lords, list of citations are placed here at page number 27. My lords, is the state of UP versus Dinesh Singh.
Yes.
My lords, here in this case, categorically they classify what is the difference between a benefit and a reservation, my lords.
Yes.
Whereas if you look at Rule 11 of the PGET regulations and the KEA regulations of 2006, which regulates the admission, reservation is what is provided and not benefit or incentive, my lords. When something is given as a matter of reservation, it creates a matter of right. And those rights cannot be taken away in an arbitrary manner. Even if there is power to exercise for decategorization, the same should not be done in an arbitrary fashion like how it has been done in the present case, my lords.
Yes.
That is the second point that I wanted to bring forth before this honorable bench. My lords, thirdly, coming to the particular aspect of the rules of the game, my lords. My lords, the rules of the game can be changed only in accordance with the rules of the game, my lords, and not otherwise. The rules of the game through the brochure has been said clearly that there is a possibility for stray vacancy rounds to be getting created in case there are ineligible candidates. And Rule 11 of the 2006 regulations, which governs the admission, also clearly states, my lords, I would just like to read out Rule 11 and Sub-Rule 2. Any seats reserved for in-service candidates which remain unfilled for want of eligible candidate or otherwise shall be added to the seats reserved for non-in-service candidates.
Yes.
My lords, this is the particular aspect that the Rule 11 subclause 2 provides for. My lords, here, is it not a matter of prudence and good faith that such power should be exercised in the stray vacancy rounds? My lords, by exercising it at the very instance of the seat allocation,
Yes.
there has been a considerable arbitrary exercise of power which has caused detriment not just to the petitioners but also to the entire constitution at large, my lords. My lords, there is a fraud that is played on here by not following the rules of the game, my lords. While I never hold that they do not have the power, rather I would say that they have the power to hold it, but however, it should only be done at the particular instance of the stray vacancy rounds. And they cannot say that they did not have knowledge of the same because 2023, a concurrent bench of this honorable court has clearly put them that decategorization should be done only in the mop-up rounds, my lords. And therefore, the good faith principle was already established much before the rules of the game was even announced. So here in that context, I would like to say that it was again arbitrary. Last and fourth point that I'd like to bring before the honorable bench, my lords, is that with regard to the NEET brochure, now while I state that it is the state government that has, and while the honorable bench has kindly pointed out multiple occasions that merit plays the norm, my lords, however, in the Tamil Nadu case, it has been clearly said that even though merits is the norm, the rules of the game for in-service quota or categorization is a valid categorization. This was what the ratio was, my lords. That is something that this honorable bench has to take note of. And here, in this particular instance, by depriving the in-service candidates, they are actually creating a fraud on that particular principle that was enunciated as well. My lords, here in this point, I would like to bring the particular aspect to merit is the norm, my lords. My lords, here when we speak that merit is the particular aspect, the NEET brochure itself provides, my lords, I just read the relevant rule. It is rule number 10.10.2 at page number 78 of the NEET brochure, my lords. It says, State quota rank, state category rank, benefit for in-service candidates shall be determined or generated by the designated agency or authority of the concerned state or union territories as per applicable regulations, eligibility criteria, guidelines, and applicable reservation policies. My lords, when the particular aspect is merit is the norm, the word reservation should never come into place, my lords. When the usage of the word has been given for reservation, then due credit ought to be given for the aspect of reservation policies that is created across, and the rules of the game pertaining to the reservation should never be allowed to be changed until the stray vacancy rounds, which is the allocation logic of the KEA itself. My lords, you cannot approbate and reprobate at the same time, my lords. So that is one of the last submissions that I have. And on this ground, I would humbly submit that the particular seat matrix that was issued on 17/12 be particularly issued by way of a writ of certiorari be nullified, my lords, to the effect. And further there too, there is just one more additional aspect that was,
All candidates you have made a party who are selected pursuant to that list.
Your lordship,
Not candidates who have got the seat.
your lordship, they are made parties in,
Your case.
your lordship, indeed not. Your lordship, indeed not.
Yes.
Your lordship, however, in the interest of justice, your lordship, it ought to be considered. Here, we do not want to take the seats of those who have been given seats. Your
Yes,
lordship.
we'll consider. Yes. Who else? Your matter is 28 points? 28.5. Yes. Yes. Yes.
So if I'm able to understand the facts of what is happening, the submissions are portrayed in this fashion before your lordship, that the reservation which has been, the quota system which has been generated under the rules is a reservation, number one. It is not a mere benefit
Yes.
or a sheer quota, but it's a reservation created under a statute. Now, I would, like the other day, I would just take my lordship only to two rules which are already there within the paper books. My lordship will have to see Rule 10, A, Rule 10, Sub-Rule 1, Subclause A. Then, my lords, Rule 3, which deals with the entrance test.
Which are the rules you're referring to?
My lords, Rule 3.
MCI rules.
No,
The
Karnataka conduct of entrance test.
Yes, yes.
Subsequently amended and
Yes,
which have
yes,
been renamed
yes.
also. So, Rule 3, Rule 10, Rule 11. It was initially conduct of entrance test rules. Then it has been renamed, as Karnataka conduct of entrance test for selection and admission to postgraduate medical and dental degree and diploma courses.
Yes.
I just pointed out, the amendments have taken place in E2 at page 61.
Yes.
So your lordship will have to read this Rule 3 in juxtaposition. Page 49 will have to be read in juxtaposition with 61 for a moment.
Yes.
You just substitute the word. Or your lordship could just substitute the word 3 in place of 5.
Yes, that's all.
That's all. That's all.
Hmm.
I would say that the other amendment, by way of a notification at E3, would not detain these candidates because it will take place possibly from the next year.
Yes.
I would only point out that the operation of Rule 3, 10, and 11, they are acting in a self-contained code.
Yes.
They stipulate the eligibility. Number one. Then minutes. The
Yes.
eligibility criteria has to be read in by virtue of Rule 3 and 10 read together. Then what happens to the seats? Post eligibility the distribution of the seats are contained in Rule 11.
Now your lordship will have to go to the brochure for a moment.
Yes,
KEA brochure ಕೊಡಿ ಒಂದು.
yes.
Your lordship will see that. Not in the KEA brochure, I'm sorry, there are no internal page numbers, but can I take your lordships to condition 8 there for a moment? Who are in service candidates are? We form a bulk.
Five.
My lordships would have, I think that there might have been a small bookmark just before that. It starts, there is a caption called PWD reservations after that.
Option entries.
On the right side of
Reservation was, yes.
instructions for in-service. Okay.
Just before the note which my lord read it, my lords. Just before that note, there is a.
Correct. Thank you. Yes,
It would have been better had it been paginated, but I'm sorry.
yes, that is something that the KEA can think of.
Next.
Pagination. Yes. Yes,
Now, my lords, sir.
yes.
Kindly see, my lords, instruction for in-service candidates. I am reading this just to point out who
Hmm.
constitute these in-service candidates.
Hmm.
A. In-service candidate means persons belonging to health and family welfare services, ESI, BBMP, boards and corporation institutions which are granted autonomous status, including persons deputed from such services to any other foreign services as per GO number so and so. Doctors working in Karnataka are considered as in-service doctors, and their seat allocation will be done under the quota of boards and corporations. So, my lords, it's not just government hospitals alone. My lords, people who work in various boards, autonomous bodies, because all of them are treated to be in-service candidates. Now, my lords, may kindly see the age criteria, 48. Then, my lords, kindly see, my lords, how the channel works in C for a moment. In-service candidate should obtain NOC from head of the concerned department and enter the relevant details in the registration form. Further, the NOC should be produced at the time of verifying the documents. Then in-service doctors will have to fulfill the following conditions stipulated under Rule 10 of the Karnataka Conduct of Entrance Test for admission to PG, PGMD and diploma courses, Rules 2006 as amended time to time. My lordship may kindly see, this is the condition proceeding. My lords, I may say one thing, my lords, the government say another thing. But my lords, this is something, my lords, which is inbuilt within the brochure here.
28.5 is filed when?
28.5 is filed, my lords, in February. I know your lordship will be commenting on my latches in approaching this one.
February 2025.
Your lordships, I think the question I'll have to counter from your lordships is 7 July is this, you come in February. This is what your lordships are going to. I'll point out the cause of action for me to come arises when because of this. I'll just point out why. I'll just point out why. So that I'll just first I'll ensure what is this. And I'll answer everyone. I know minutes.
4 rounds.
I know minutes that even a day's delay minutes in a writ can be fatal. I pointed out on the last occasion. I know that minutes. I'll just.
Yes. First time the parties are coming in a 2025 petition. February 2025.
They are not served also. The response have not.
They have been served.
Even otherwise, after
The
4
private
rounds.
respondents have been served.
Served,
Served.
Served.
They're there before this one.
even if everything you say is
Yes,
after 4 rounds of counseling on this,
I will just, I'll just,
this
yes.
brochure with this provision being there from 10/20/24 onwards, being considered by this court, a single judge of this court in an earlier round, and now you come and say,
I,
and now you.
may I
you think
take,
of
I'll
making
just
the
point
party.
out to the learned single judge's order also. I'll just
You've
take
seen
my
the learned
lordship.
single judge's order. It is not a direction, it is an acceptance.
It's a consent.
By those persons who are
It's-
there
it's-
on record at the relevant time, going by the criteria privilege.
Correct, Lords. Can consent confer jurisdiction or a right? I'll just answer
Consider.
that.
Yes.
Please, Lords. Now, my lords, I'll just E for a moment thereafter.
Mm.
The channel postulates, my lords, that the HODs of each of the departments shall forward the application of only such candidates who fulfill all the criteria mentioned in the application form. Then, my lords, G.
Yes.
In-service candidate who has completed 3 years of regular service. This is, my lords, that is why I said 3, not 5 and 3. After the successful completion of probationary period, as on 31st March, in which the entrance test is held, shall be eligible for admission under these rules and is eligible to apply for CET and to participate in the counseling. Next, in-service candidate shall be eligible for admission to PGD and diploma courses in any subject. An in-service candidate who is already holding a PGD in a specialty shall be eligible for PG degree courses. Then, the H for a moment. In addition to the above,
Yes.
in-service doctor should furnish the information sought in the application form, and the heads of department should verify and forward the applications to the DME, who will in turn forward them to the executive director, KEA, Malleshwaram so-and-so. The concerned heads of the department, that is directors / heads of autonomous institutions, respect of medical education, health and family welfare, and heads of other boards and corporations should verify and approve the details entered by the candidates online through KEA portal for NEET PG24 or NEET MDS24 with credentials provided. The seats within in-service quota shall be reserved as per MCI, DCI of government issued from time to time. Any seats reserved for in-service candidates which shall remain unfilled for want of eligible candidates or otherwise shall be added on to the non-in-service quota as per government/DME instructions.
Yes.
Please, ma'am.
Which shall remain unfilled for want of eligible candidates
Or
or
otherwise.
otherwise
Or
shall be added to the non-in-service
this-
quota seats
Yes,
as
ma'am.
per government DME
Yes, ma'am.
instructions.
Now,
Yes.
your lordship will have to, I don't know, but I'm just putting this.
Those who would have been eligible. They've all been.
Yeah, but they got seats.
In the other writ petitions, what has been argued? In the other writ petitions, what has been argued possibly is this. When will this power be exercised? When can this power be exercised? Because your lordships are aware. We have primary rounds of counseling, secondary, then your lordship will see that mop-up is there. Then, my lords, lastly, the string. So, my lords, will this be available to all these candidates? And will all these rounds of counseling be available to all of us, my lords, even subject to my lords, the revision of eligibility scale by the NEET? It's a question, my lords, it's a question. Because, my lords, eligibility on the merit is one thing, then eligibility, my lords, of the reservation within the merit is another thing. Now, there is one thing which is apparent, that the authorities, my lords, in haste, they have thrown open this, and this is happening year after year.
Yes, we'll consider.
This is happening year after year. Then, my lords, rounds, lords, lords, I think your lordships were shown about the number of rounds which are involved.
Yes.
Lords, again, my lords, I can just point out how these rounds have to work in case where there is reservation. Unfortunately, my lords, I'll show my lordship how these rounds work within a reservation. Lords, can I take my lordships to There's a flow chart within this. 2 pages after that. That's the best bookmark I can handle. Some 6, 8 sheets after where we stopped. There's a flow chart. And 2 pages after that. Now, if there is a reservation, my lords, kindly see how the brochure itself is dealing with it.
Yes.
Just dealing with a, your lordships are saying reservation, it
Yes.
favors certain categories. It says Hyderabad, Karnataka. Then it says persons with disabilities. Then with SC/STs and OBCs. Linguistic, religious minority. Then let's kindly see.
In-service does not find any place in the reservation.
They've given certain categories.
Yes.
Certain categories.
Yes.
Not everything is included here. Kindly
Yes.
see, this is reservation in reservation, which is what we wanted to point out.
Yes.
Now, your lordship will see the counseling procedure there.
Yes.
Subclause 4.
Yes, please.
The seat matrix issued by the government for each discipline will be adopted for allotment seats. College-wise, course-wise, and category-wise seat matrix issued by government will be hosted on the KEA website for information of candidates and parents. The online allotment will be based on merit, priority of options entered by candidate, and roster prescribed by government. Lastly,
Yes.
eligibility to participate in each round is subject to conditions stipulated from time to time by MCC.
Yes.
This is what I wanted to point out.
Yes, that has
Eligibility
already
to-
been pointed out.
Yes. KEA will not be held responsible in this regard.
Yes.
Online allotment of seats will be conducted in multiple number of iterations.
Yes.
First round, second round, mop-up round, stray vacancy.
Yes.
Then there's order of online seat allotment in the first round. Persons with benchmark disabilities.
Yes.
Then kindly see. Common merit list of in-service and non-in-service candidates. After disabilities, immediately. The seat will be allotted to the eligible candidate as per the roster system and the seat matrix issued by the government and based on the options entered by the candidates. Now, the question which will arise is, has this, the procedure which has been postulated within the brochure stands followed or not?
Yes.
Stands followed or not? If yes, I don't think we have a chance.
Yes.
If no, I think we still have a striking chance.
Yes.
Then the procedure for allotment of seats and so and so. Your lordship will see the seat allotment logic thereafter.
Yes.
What is the last line there? With the seat allotment logic.
Yes.
Based on the seat matrix issued by the government, action will be taken to allot the seats to candidates based on the eligibility and reservation criteria. The options entered by the candidate will be considered for allotment based on merit. While allotting the seats to candidate, the computer will check the availability of seats for each option based on priority of options. The order of allotment reservation for each category is detailed below for the information of the candidates. But this is how the allotment of seat in a particular candidate is based on his or her rank and priority option is entered. In any category, the candidate option is searched in general category and allotted. If no seat is available in general merit category, the computer searches in the Hyderabad general merit quota and allots the seat. If seat is not available in either GM or GMH, then it follows the priority order as shown above. This improves the category of seat allotted to roster in the same manner, so and so categories.
Yes. Yes. We'll come back by 3. There is a habeas corpus matter which has to be heard in chambers.
Serial number 53, your lordship.
Please give a date.
More than 10. More than 10.
But that serial number 26, my lord, matter may be referred to.
Usual orders.
Karnataka litigation. When they will appear, appearance date, appear.
Date and time, please.
3 PM. ಒಂದು ನಿಮಿಷ ಇದೆ.
Yeah. 26. ಒಂದ್ ನಿಮಿಷ ಎಲ್ಲಾರ್ಗು ಹೇಳ್ತೀನಿ ರೆಫರ್ ಟು ಮೀಡಿಯೇಷನ್ ಯಾವಾಗ ಅಪಿಯರ್ ಆಗ್ತೀರಾ 5th ಮಾರ್ಚ್ ಅಟ್ 1 ಬರ 3:30 ಅಥವಾ 11:30 ಆ ತರ ತಗೊಳ್ಳಿ 3 PM 12 12:30 ಅಂತ ಹಾಕಿರ್ತೀವಿ 12:30 KMC Karnataka Mediation Center at Bangalore. ಯಾರೋ 53 ಯಾವ್ದೋ ಹೇಳಿದ್ರಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಮುಂದೆ 53 ಆಯ್ತು ನೀವೇ ಮೇನು ಹೇಳಿ ಅವಾಗ ಅವೆರಡು ಬಿಟ್ಟು ನಾನು ಡೇಟ್ ಕೊಡ್ತೀನಿ ತಗೊಳ್ಳಿ 18/3 ಒಂದ್ ನಿಮಿಷ 53 ಇಲ್ಲ 51 ಹೇಳಿ ಸರ್ ಕೇಳಿ 20 ಮೇಲೆ ಯಾವಾಗಾರು ಕೇಳಿ ಮಾರ್ಚ್ RFS ಕಷ್ಟ ಸರ್ ಹೇಳಿ 20 ಕೊಟ್ಟಿರ್ತೀನಿ 23 ನೆಕ್ಸ್ಟ್ ಯಾರು ಹೇಳಿ ಒಂದು ನಿಮಿಷ 55 11 ಕೊಡ್ಲಾ 14 ಕೊಡ್ಲಾ 14/3 ನಿಮಿಷ 56 ಹೇಳ್ಬಿಡಿ ಯಾರದು ಇನ್ನೊಂದು ಪರವಾಗಿಲ್ವಾ ಒಳ್ಳವ್ರು ಒಂದ್ ನಿಮಿಷ 26/3 ಕೊಟ್ಟಿರ್ತೀನಿ ಆಮೇಲೆ ನೋಡಿ ತುಂಬಾ ದೂರ ಆಗುತ್ತೆ 26/3 ಮತ್ತೆ ಅದೇ ವರ್ಕಿಂಗ್ ಇರೋದು 27, 28 ಹಸಿರು ಕಲರ್ ಇದೆ ಯಾಕೆ ರಾಮಾಯಣ 56 12 14 ಕೊಡ್ಲಾ ಅಥವಾ 18 ಕೊಡ್ತೀನಿ 36 ಉನ್ಮೇನಾ ಒಂದ್ ನಿಮಿಷ ಸರ್ 34 ಹೇಳಿ 18/3 36 34 ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಮೇಡಮ್ 35 ಮೇಡಮ್
7/3 34
35 ಮೇಡಮ್
35 ಯಾವಾಗ ಬೇಕು ಹೇಳಿ ಸರ್
ಬೇಡ ಮೇಡಮ್ ಅದು ಮೊನ್ನೆ ಒಂದು ಮ್ಯಾಟ್ರ್ ಇತ್ತು ಫೆಬ್ರವರಿ 20th
ಬನ್ನಿ ಸರ್ ಮಧ್ಯಾಹ್ನ
ಓಕೆ ಆಯ್ತು ಮೇಡಮ್
40 ಹೇಳಿ 30 30ನಾ 40 21 ಕೊಡ್ಲಾ ಜಗಬಿಡಮ್ಮ ಒಂಚೂರು ರಜಾ ಇದೆಯಲ್ಲೋ ನೋಡೋಣ 21/3 ರೀಚ್ ಆಗಲ್ಲ RFS ಬನ್ನಿ ನಮ್ ಹೋಟೆಲ್ ರೀಚ್ ಆಗಲ್ಲ ನಮಗೆ ರೋಸ್ ಬರುತ್ತೆ ಅದೇ ಗೊತ್ತಿಲ್ಲ ಎಲ್ಲ ಹೋಗೋದು ಅದು ಶುಕ್ರವಾರ ಬೇರೆ ಮತ್ತೆ 42 19/3 ಆಗ್ಲೇ ಆಗೋಗಿದೆಯಲ್ಲ ಅಲಾಂಗ್ ವಿತ್ ಲಿಸ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ ಬೆಳಗ್ಗೆನೆ ಆಗೋಗಿದೆ ಅದು ಒಂದು ಡೇಟ್ ಬೇಕಾ 21/3 46 ಹೇಳಿ 14-3, 14-3. 14-3. 50? 58. ಹೇಳಿ. ನೆಕ್ಸ್ಟ್ ಮಂತೇನೆ, ಅದ್ರಲ್ಲಿ ಡೌಟೇ ಇಲ್ಲ. 25. 25. ನೆಕ್ಸ್ಟ್
ಮೇಡಮ್ 56 ಅರ್ಜನ್ ಆಯ್ತಾ ಮೇಡಮ್?
56 ಅರ್ಜನ್ ಇದೆ. 26-3.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
52 ಹೇಳಿ. ಇಪ್ಪತ್ತೈದು 3. ಥರ್ಟಿ. ಫಸ್ಟ್ ಮಾತ್ರ ರೆಡ್ ವಾರ್ ಫ್ಯಾಕ್ಟರ್ ಇವತ್ತೇ ಬೇಡವಾ? ಶಾರ್ಟ್ ಅಂದ್ರೂ 7-3 ಶುಕ್ರವಾರ. 25. ಯಾವುದು? 1 ಪಾಸ್ ಅವರ್. ಪಾಪ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತೀನಿ. ಏನಾರು ಮಾಡಿ ಸದ್ಯಕ್ಕೆ ಇವಾಗ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. KMC ಬೆಂಗಳೂರು ಅದೇ ಮಾಡಿದ ಡೈರೆಕ್ಟರ್ ಜಾಯಿಂಟ್ ಇದು ರೆಫರ್ ಟು ಮೀಡಿಯೇಷನ್
2:30 PM. 2:30 PM.
12:30. 2:30 PM. 26 PBK. ಇಟ್ಟಿದ್ದೀನಲ್ವಾ ಫೈಲು ಇಲ್ಲಿದೆ. ಆಮೇಲೆ 28 ನಡೀತಾ ಇದೆ. 29 ಇಟ್ಟಿದೆ. ಫೈನಲ್ ಇಯರಿಂಗ್ 30. 25-3 ಹಾಕೊಳ್ಳಮ್ಮ. ಆಮೇಲೆ 31, 32 ಅವಾಗಲೇ ಆಗಿದೆ. 33 ತಗೊಳಪ್ಪ. 18-3. 34 ತಗೊಳಪ್ಪ. 7-3. 35 ಇಲ್ಲೇ ಇದೆ. 65 ಇರಲಿ. 36 ತಗೊಳ್ಳಿ. 18-3. 560. ಆಮೇಲೆ 37 ಬೆಳಗ್ಗೆ ಹೋಗಿದೆ. 38 ಇದೆ. 39 ತಗೊಳ್ಳಿ. ಅಲ್ಲ ಅದು ಹೋಗಿದೆ. ಇಲ್ಲ 38, 39 ಬೆಳಗ್ಗೆ ಹೋಗಿದೆ. 38 ನಮ್ಗೇನೆ. 40. 21-3. 42, 43 ಹೋಗಿದೆ. 41 ನಮ್ಗೇನೆ. ಆಮೇಲೆ 46, 230 ಇರುತ್ತೆ. 15-3. ಎಲ್ಲ ಇರ್ಲಿ. 160 ABK ಆಗಿದೆ. ಕರೆಕ್ಟ್. ಅದನ್ನ ತಗೊಳಮ್ಮ. 43, 21-3. 44 ಆಯ್ತು. 45, 46, 44 ಬೇಡ. 44, 45,
46, 14-3.
14-3, 46. 47 ನಮ್ಗೆ. ಇನ್ ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ನಮ್ಗೆ. ಆಮೇಲೆ ಸೀದಾ ಬನ್ನಿ ಎಲ್ಲಿಗೆ? 51ಕ್ಕೆ ಬನ್ನಿ. 20 ಬನ್ನಿ. 23. 2190 ತಗೊಂಡ್ಬನ್ನಿ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ತಗೊಳ್ಳಿ. 1695, 25-3. ಆಮೇಲೆ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ತಗೊಳ್ಳಿ. 18-3. 57. 50 ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಹೊಟ್ಟೋಗಿದೆ. 55. 55 ತಗೊಳ್ಳಿ. 1069. 1069. 14-3. 56 ತಗೊಳ್ಳಿ. 168 ತಗೊಳ್ಳಿ. 26-3. 57 ನಮ್ಗೆ. 58, 25-3. 71. 30 ನಮ್ಗೆ. ಒಂದ್ ನಿಮಿಷ. 3, 25-3.
58 ಆಯ್ತು.
ಲಾಸ್ಟ್ ಅದೇ 25. ಏನಮ್ಮ ಹೇಳಮ್ಮ. ಎಲ್ಲ ಚೆಕ್ ಮಾಡ್ಕೋತಾರೆ. ಏನ್ ಯೋಚನೆ ಮಾಡಿ. ಎಲ್ಲ ಚೆಕ್ ಮಾಡಮ್ಮ. ಇಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್. ಓಕೆನಾ? ರೈಟ್. ಬಾಯ್. 1:30, 2 ಗಂಟೆ ಅಷ್ಟೊತ್ತಿಗೆ ಮುಗಿಸಿರ್ತೀವಿ. ನಮಗ್ ಚೇಂಬರ್ ಇದಿದೆ. ಇನ್ನೊಬ್ರು ಕೊಡಕ್ ಸರ್ ಇರ್ತಾರೆ. ಅವ್ರನ್ನ ಇಲ್ಲೇ ಇದೆ ಫೈಲ್. ಕೇಳ್ಬಿಟ್ಟು ಮಾಡಿಸ್ಕೊಳಂಗಿದ್ರೆ ನಾವ್ 2:30 ಚೇಂಬರ್ ಇದ್ದಿದೆ. ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡು ನಿಧಾನಕ್ಕೆ ಬರ್ತೀವಿ. ಅಷ್ಟ್ರೊಳಗ್ ಮಾಡಿ. ಅರ್ಜನ್ ಆಯ್ತು. 6-3. ಅದಕ್ಕೆ
ಕೊಡೋ ಇಲ್ಲಿ ಕೊಟ್ಟು ಕಳಿಸ್ಬಿಡೋಣ ಇವ್ರ ಕೈಲಿ. ಹೌದು ತಗೊಂಡ ಕೊಟ್ಬಿಡು, ಅದು ಎರಡು ಎತ್ಕೊಂಡು. ಆಯ್ತು ನೋಡು ಗುರು, 1, 2, 3, 4, 5 ಪಾರ್ಸಲ್. ತಗೊಂಡಿದ್ದೀರಾ?
ಅಶ್ವತ್ಥನ ಮಾತು ಕೇಳ್ತಾ ಇದೆ ಅಂತ ನಾನು ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಲಡ್ಡು ಕೊಡ್ಲ ಲಡ್ಡು ಅಷ್ಟೊತ್ತಾರೆ. ಹಾಕಿದ್ಮೇಲೆ ಏನೋ ಗೊತ್ತಿದ್ದಂತೆ ಬರ್ಬೋದು, ಇನ್ನೊಂದು ಸರಳ ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತಾರೆ ಅಂತ ಗೊತ್ತಾಗ್ತಿಲ್ಲ.
ಒಂದ್ ವಾರ ಎಲ್ಲ ಅಟೆಂಡ್ ಮಾಡ್ತಾರೆ.
ಒಂದಿಂದ ಬರ್ತೀವಿ, ಈಗ ಎಲ್ಲ ಕೂತ್ಕೊಂಡ್ ಬರ್ತೀವಿ, ಯಾರು ಅದಕ್ಕೆ ಅದಕ್ಕೆ ನಾವು ಡೇಟ್ ಕೊಡಲ್ಲ ಅಂತ ಬೇಜಾರ್ ಮಾಡ್ಕೊತಾರೆ. ಇಲ್ಲ ಲಾಸ್ಟ್ ವೀಕು ಆಗಲ್ಲ ಅಂದ್ರೆ ಕೇಳಲ್ಲ ಅಂತ. 80-86 ಮ್ಯಾಟ್ರಲ್ಲಿ ಎಂತ ವಿಚಾರಕ್ಕೂ ಎಲ್ಲ ಇದೆ. ಈಗ ಏನು ಹಾಕ್ಬೇಕು, ಇನ್ನೂ ಮುಗ್ದಿಲ್ಲ, ಅದು ಕಂಪ್ಲೀಟ್ ಆಗ್ಬೇಕು. ಅದು ಮುಂಚೆ ಪೇಪರ್ ಮುಗಿಸ್ಕೊಂಡು ಬರ್ಬೇಕು. ತಗೊಂಡೋಗಿದ್ದಾರೆ, ಅರ್ಜೆಂಟ್ ಮಾಡೋದೇ ಯಾವ ಒಂದ್ ಕಿತ್ತಕ್ ಹೋಗ್ತಾರೆ, 4 ಬರುತ್ತೆ. ಬೇಕಾ ಮಾಮೂಲಿ ಲಡ್ಡು ಅದೇ ನೀವು ಕೊಟ್ರಲ್ಲ ಅವತ್ತು.
ಅದೇ ಚೇಂಬರ್ 2:30 ಸರ್ ಹೋದ್ರೆ ಫೋನ್ ಮಾಡ್ತೀನಿ ತೆಗಿತಲ್ಲ ನೋಡಿ ಸರ್ 2:30 ಅಷ್ಟೊತ್ತಿಗೆ ಆಯ್ತಾ ಸರ್ ಚೇಂಬರ್ ಅಲ್ಲಿ ಒಂದು ಮ್ಯಾಟ್ರ್ ಇದೆ ಮುಗಿಸ್ಕೊಂಡು ಬರ್ತಾರೆ ವೇಟ್ ಮಾಡಿ 28 ಆದ್ಮೇಲೆ ಪಾಸ್ ಅವರ್ಸ್ ಆಮೇಲೆ ಫೈನಲ್
39
ಸರ್ ಈಗ ಈ 28 ಎಜುಕೇಶನ್ ನಡೀತಾ ಇದೆ ಆದ್ಮೇಲೆ ಪಾಸ್ ಅವರ್ಸ್ ಆಮೇಲೆ ಫೈನಲ್ ಒಂದು ABS ಕಾರ್ಪಸ್ ಇದೆ ಮುಗಿಸ್ಕೊಂಡು
ಬಂದಿಲ್ಲ ಆಗಿದೆಯಾ 4473
ಹೌದು ಸರ್ ಈ ನೆಟ್ವರ್ಕ್
ಏನಾಗಿದೆ
18 ಬೆಳಿಗ್ಗೆ
ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗುತ್ತೆ
ಎಲ್ಲೂ ಇಲ್ಲ ಬರಿತಾ ಇದ್ದಾರೆ ಬರ್ತಾರೆ
Number 15
Continuation, number 28.
Yes.
Need brochure for a moment. Just that.
Yes.
The relevant provision 9.2.
Yes, this has all been argued. Please don't, we have so many other matters which are passed over. Please don't repeat anything. Yes. Yes, yes. Yes. Counsel, what are you referring to? Sorry?
Turn the mic. Enable.
The rules what I have been referring to, my lords, is the conduct of entrances rules.
Hmm.
Not if this can be relaxed in some form or the other. The procedure for relaxing the same is to, my lords, amend the rule. Not by a
Yes, we
notice.
understand that.
Yes.
That has already been argued.
And
Yes.
it has to be done by the legislative process by placing it in front of the legislature for its approval. So now, my lords, the ultimate issue what is there before your lordship says whether this circular can undo the rule or not. And for that, my lords, I'll just place my hands on a couple of judgments which have been.
That you don't need to bother.
Yes.
We are aware of this.
To that
Yes.
extent, my lords, these are the judgments, my lords, starting from 66 Supreme Court, B.N. Nagarajan's case, constitutional bench judgment. So
Yes.
there they have said, my lords, a rule cannot be subsumed by a virtue of a circular unless the legislative process has been followed. So this is the law on that point. Not then coming to the last aspect of the matter, my lords, I think the page, my lords, the last issue, my lords, is everybody has been arguing on that rules of the game cannot be changed. So, my lords, there is a question and a counter question to both sides here. NEET has revised the mark scale. So the question, my lords, is I am in a catch-22 situation before your lordships today. Then when, my lords, the counselings went on, I was not eligible. The moment, my lords, I have become eligible, my lords, there is a decategorization or a de-reservation of seats and there's no quota seats. Hence, my lords, the way it should have been done was in consultative process where, my lords, the NEET or the examination body would have been intimated that insofar as these marks are concerned, the state quotas are not getting filled up. And, my lords, if there was no revision thereafter, they could have gone ahead with the matter. Here, my lords, unfortunately, the de-reservation has been done even before, my lords, the mop-up vacancy has come in, mop-up round has come in. And thus, my lords, it has caused a, there has been a short circuit in the procedure within all brochures. And thus, my lords, the students who could have been otherwise eligible, their rights have been thrown away into the wind. And that is why, my lords, we are there before this court. And ultimately, what we are requesting this court, there are a series of writ petitions. I would request that all these writ petitions may be considered together because we are all before this court under a common cause.
And one of them we are challenging in my writ petition, we are challenging the candidates who have gone into my in-service quota candidates who have gone into because of their ineligibility due to non-compliance of Rule 10, Sub-Rule 1A there.
Yes,
That not being complied and reliance being placed on executive circular. I would point out that executive circular is ab initio void and in contravention to the rule. And something which is ab initio void need not be even called into challenge because it is void. But however, there are acts which are being taken up on that.
it is a strange proposition. Anyway,
I'll just
yes,
an act which is void ab initio requires no challenge.
yes,
An voidable act
yes, yes.
an act which is voidable requires a challenge. An act which is voidable. That is why I placed reliance insofar as the judgment by the constitutional bench.
Yes. Yes. Yes, yes,
Please, Lords.
yes.
Then
That's
Lords,
it.
the last judgment was Tej Prakash Pathak, the rules of the game cannot be changed.
Yes, we'll consider. Yes.
Anything else, my Lords, I think we can tender.
Yes, no, no, not anymore. You've argued, please.
That's all.
Yes. What do you say?
Lord, I'll not take the Lord's much time. Lord, they refer to two judgments, my Lord. One is
Could we pass on this compilation, Lord?
Yogendra J. Ram.
Need not be. The positions that you are seeking, don't
Very-
bother with it. Yes,
One is Yogendra J. Ram, which they relied
Yes.
upon. Lord, that judgment, my Lord, there was an interim order as to not to
Yes.
decategorize.
yes, we've seen that.
And Lord, insofar as decategorization itself is concerned, my Lord, it's been covered by a coordinate bench order, WP number 6735 of 2022, my Lord, which I have produced. Lord, it has been upheld by the Honorable Apex Court also.
Yes.
Like, my Lord, para number 5 onwards, my Lord, they've considered both the contentions
Yes,
and said that the decategorization, which was already produced in the brochure, was held to be para number 7 may be relevant. We have considered the submissions made on both sides and have perused the record. Admittedly, after the examination was held on 11/9/21, the authority had issued an e-information bulletin pertaining to the NEET PG so-and-so in the month of December before the counseling had commenced. The aforementioned information bulletin clearly provides the seats of in-service candidates which remain unfilled for want of eligible candidates shall be filled up from amongst the non-in-service candidates. The petitioners have not challenged the aforesaid stipulation provided in the information bulletin. It is pertinent to note that admittedly all remaining vacant seats of in-service candidates have been filled up in the second round of the counseling as on so-and-so. At this point of time, there are no vacant seats of in-service candidates which can be made available to the petitioners for their admission. Therefore, the petitioners have neither chosen to file the particulars of the candidates who have been selected against the in-service candidates, nor have implemented them in the writ petition. Therefore, at this point of time, no relief can be granted to the petitioners in the absence of the candidates who have been admitted against the vacant seats of in-service candidates after the first round of counseling. The petitioners do not have any existing legal rights to seek a writ of mandamus to the respondents to insist that the seats which are already been filled up should be decategorized and should be treated as in-service category seats. The petitioners are eligible to appear in the mop-up round as general category candidates and would be given admission if found eligible. And Lord, this has been affirmed by the Honorable Apex Court also.
yes.
Please.
I misquoted a statutory provision. It is section 25, section 23 of the Capitation Fee Act. Power to make rules or amendment thereafter. 23, rule 3, as a subsection 3. Rules will have to be made in terms of 23, subsection 23.
Yes,
I repeated earlier, the concept of decategorization is not
to see that, my lord, the merit is not suffered. Whether no candidate, this should go to the next available candidate, not to a candidate who is in anticipation. It may, but the percentage lowering is a fortuitous circumstance. It may happen, it may not happen.
Yes.
So therefore, my lord, it doesn't inure to their benefit. It's covered by decision of your lordship.
Yes.
On these matters, the state is the contesting respondent on the 2 points, eligibility of 3 years, as well as on decategorization. We have no role to play.
Yes, yes. Yes, what about the other matters? Anything further? Yes. Reserved.
Yes, sir. We have only one request, my lord.
Just leave it just like that. Notes I've made in the judgment.
28th is the
Exactly
date.
made in the judgment, just keep it exactly like that.
There be a
Yes.
small request, it's the last indulgence. The lordships are anyway going to announce the judgment.
Yes,
By 28th, my lords, our fate will be sealed.
yes,
It's not so. In
Yes.
case, my lords, if it is an adverse thing, my lords, so that we could.
please counsel. This I could have done in the morning if you had not insisted on arguing what
Yes.
what has
try
been
and-
argued repeatedly even thereafter.
We-
We are sorry. Yes,
All right.
It will
We are
come when
grateful
it-
for the indulgence.
it will come when it comes. Sorry.
Very grateful for the.
Yes,
And grateful for the audience. my lord. We are grateful.
I appeal for respondent number 3.
But for the petitioner,
yes.
29.
my lord, senior is traveled to Dharwad. So is it, I mean, request you to post it for tomorrow. It was an urgency, that's why. It was an urgency.
Efficiency, it must be argued, shouldn't it? Opposed. MD Pediatrics, Akash Institute of Medical Sciences. Held the mop-up round, petitioner was not allotted seat.
Selected candidate.
Ah. Both of them have got seat. Yes. Day after tomorrow. Day after tomorrow, we cannot have. Yes.
Possible tomorrow?
The day after that. Yes.
27.
Passos. Okay.
List 3, passed on matter.
Video number 4, what's out matter? Pension matter 4 times it has been adjourned.
List
Just a
3.
moment, please.
Sumitra GM.
Sorry, I have very bad throat. I may be tolerated. Bad throat.
Port fee
Is it the
exemption
one
certificate and government notification. What is this?
28831. Yeah, no, put up, in this case, port fee had been paid already. Kindly see the memo.
Has been paid.
There was some deficient was there. Now that the government order has come, it has not. And this had come up before quota number 2. The learned senior judge, since he had dealt with this matter, he said it's not appropriate. That's why I'm before your lordships. I tried to file 2 memos.
Everything is paid.
Yes, yes, yes. Now it's exempted. So 5,000.
Legal,
Kindly see the memo.
legal aid.
Yes, yes, legal. And I filed a memo there, 2 memos. There's a connected matter. Both may be kept because he has already obtained an order of status quo. I don't want conflicting judicial orders. Kindly take this memo. And
Could we come before the same meeting?
matter is proceeding
Have to
export.
get, we'll have to get orders for this.
Coming for admission. They have already taken an interim order against me, ex parte.
In which case, sir?
In this case only, cross appeal.
Cross
appeal.
appeals.
Yes, cross. Both these matters may be put together.
on Monday is by request. Very respectful request. Because there shouldn't be any conflict of. Please, your lordships. Monday I have.
Visit court fee has been paid.
And
The remaining court fee is concerned.
this appeal, in fact, was filed earlier. I'm reminded of that poem, what they call Pied Piper, because she was not able to gather the money. But the other man who was more in affluent circumstances was able to take an order against me. Monday. Please, your lordships. Thank you.
Going to be posted along with MFA.
Two number.
2531 of the.
253.
To verify.
2531.
Is the next steps. Yes, sir. Hey, madam. Not yet.
Third. List 1, past door matters, admission, seal number 1,
I'm for
Authorized Patel.
Petitioner in 1.1 and 1.2, my lord. In 1.2, I may be permitted to carry out the amendment that legal has brought a legal.
See,
I will, here
vacation,
itself, I will carry out.
Option. Your initial appointment was in the aided college.
Yes, my lord. JOC, on the JOC.
You've been, your absorption is in the aided college. Now, what do you want?
Subsequently, they have not, supposed post was not given. That clerk post, that was given to me, my lord.
Right, that's it, that's it. What is your contention in the appeal?
Writ appeal, my lord, I filed a writ appeal on it.
What is the contention in the appeal? What was the finding of the learned single judge? Government takes a matter of decision as a matter of policy to protect both government lecturers and lecturers working in private aided institutions. There is no scope for challenge. Petitioners who are working in private and government aided colleges, they also have been extended the benefit. Any arbitrariness. They were absorbed as FDA, SDA. Absorbed under Karnataka government, giving them posting as lecturers and or any other technical post commensurate with their qualification. At least they got a job. At least they got a job.
Then they have, because
Counsel, you got a job, you were absorbed. You
Got
were
a job, my
absorbed.
lord. Earlier, I was doing a lecturer's post, my lord.
JOC. The job was JOC.
Yes, ma'am.
Now, in job oriented courses, you were
Yes, my lord.
you were absorbed in SDA, FDA vacancies, available vacancies.
Yes.
What further can be done?
Kindly have it next week, my lord, I will ready it.
There is. What next week comes? Nothing here. Your
I'll come with
contention
the-
is that government teachers have been given something else. You are not a government teacher. You were never a government teacher.
I'll come with it next week, my lord. Okay.
Yes, at the request of the learned counsel for the appellant list after maybe 3 weeks.
I may be permitted to carry out the amendment.
Number 2.
Amendment has not been allowed, counsel. Only cost title.
Yes, ma'am.
Only cost title.
Yes, my lord.
Yes. Yes, please carry out the amendment.
Number 2. Prithvish.
Income director. Seniority.
Yes.
What is the rule?
That the cadre and recruitment rule that would describe at page number 170.
170.
Yes. That's why I'm so sorry. Next G Malad would that
Just a moment, please.
be
170. Yes, it's here. Annexure G.
G.
Yes. Subsequent income director.
Yes, subsequent D from director, clause 2.
Hmm.
5 senior most willing professor as per the cadre-wise seniority list of professors. Now, this is the
Senior most willing professors.
Yes.
As per cadre-wise seniority list of professors.
Therefore, the issue now is who are the 5 most senior most professors?
Hmm.
Now, by virtue of the judgment of the learned single judge,
Hmm.
the seniority list is to be drawn up on the basis of entry into the institute.
Hmm.
As lecturer or assistant professor in whatever cadre, the entire length of service, my lord, in the institute is to be counted for determining the senior most professor.
5 senior most willing professors. So there is specific seniority in the cadre of professors.
In the cadre of professor, there is individual seniority in respect of each subject. Now, my lord, all of that will be merged together and the seniority list is drawn up, which was challenged, my lord, by the writ petitioner on the ground that it is not the date on which the person enters into the cadre of professor that requires to be counted. What requires to be counted is the total length of service in the institute.
It has to be in the cadre of professor. So there is a cadre-wise seniority list prepared.
Yes.
There is a cadre-wise
Yes.
seniority list.
That was the seniority list of professors of the Bangalore Medical College and Research Institute was called in question, saying that you have assigned seniority based on the date of entry into the cadre of professorship and not into the original cadre.
Hmm.
The entire premise, of course, I'll take a logic through the pleading which are contrary to each other, but the entire premise is somebody has entered as assistant professor or lecturer in orthopedics, whereas somebody in cardiology, somebody in neuroscience. Now, in each of these respective disciplines, the person, though all of them are appointed together, the person in cardiology may get professorship much earlier to the other, whereas somebody else will get later. Therefore, seniority list cannot be drawn up on the date of entry as professorship, but as on original date of entry into the service.
But what would be the point of saying cadre-wise?
Cadre-wise, let us assume that 5 of us are appointed together. I become professor first. Then my seniority will be counted in the professorship from the date I become the professor. Whereas the contention of the petitioner, writ petitioner was.
Oh, that is not your contention.
No, my contention is only from the date they become professors, it has to be counted.
Which is why it is called cadre-wise.
Cadre.
What does a learned single judge find?
Learned single judge relies upon a judgment. But before that, may I just draw your lordship attention to the prayer in the writ petition, page 76. Before I take your lordship to the prayer, page 76. Was the seniority list of 2018 and one of 2019. The second prayer, that if they had stopped it there and said, please do it in accordance with the cadre and recruitment rule, no difficulty. The difficulty is that direct the first respondent by issue of writ of mandamus to prepare the combined seniority list of professors working in the institute on the basis of total length of service in the teaching cadre, commencing from date of entry into service as lecturer or assistant professor, strictly in accordance with the law declared by the Supreme Court in state of Andhra Pradesh versus Dr. N. Ramchandra Rao, reported in so on. So, the entire premise was on the basis of the judgment in Ramchandra Rao. May I just straight away draw a learned single judge has also relied upon it. Let me just take your lordship to 3 pleadings, my lords, in the writ petition. First pleading in the writ petition, my lords, which is available at page 64, was that
the writ petitioners and the answering respondent, my lord, were appointed by direct recruitment by KPSC. And the Public Service Commission, my lord, prepared a combined merit list. They have produced that as annexure B to the writ petition at page number 91. Page 91. Therefore, the submission was the merit list is prepared by the KPSC on the basis of merit. This ought to be the seniority list in the cadre of, in the feeder cadre also. I objected to this on the ground that each subject is a separate cadre. KPSC possibly cannot prepare a combined merit list of assistant lecturer in orthopedics, cardiology, and neuroscience. Each of it is a different cadre. There is no combined merit list. Actually, my lord, I disputed the position. I applied under RTI, and KPSC, my lord, gave a reply saying that no, we have not given any combined merit list. We don't have it. Combined merit list will be done by the appointing authority, not by us. We have not done anything as such. Annexure B, my lord, was disputed. The next important pleading, my lord, your lordship will find that page 66, para 5 of the writ petition. That the basis of getting professorship is on the basis of seniority in the feeder cadre of assistant associate, purely on the basis of seniority cum merit. Para 5. Para 5. Writ petition, page 66.
Para 5 says the Department of Personnel and Training. Is that how it starts?
Your lordships are
There is no specific.
page 66, my lord, 60
Just a moment.
of the paper book, volume 1.
66.
Yes.
Just a moment, please. Yes.
Volume 1.
In the institute.
Yes.
Yes.
There are teaching departments spread over 45 specialties and 60 super specialties. In each of the, there are assistant professor, earlier known as lecturer, associate. In respect of course of associate and professor, in each, the cadre and recruitment rules require that such post shall be filled under promotional. So admitted cases, my lord, we were all promoted to the cadre of professorship. My lord, the next important pleading, my lord, which your lordship will find that para 7, page 68. The list of super specialty and specialty courses, my lords, are admitted. That there are various specialties and super specialty. Then at page 69, the writ petitioner would also admit, my lords, that the recruitment of teaching staff to these specialties is in respect of each specialty and not, my lord, the combined recruitment. Now, my lord, insofar as cardiology, if there are 5 vacant posts, only 5 people will be recruited. It is not as if, my lord, all the posts of assistant professorship in the institutes are combined and then recruitment is made. That is not the case. They specifically admit it is in respect of each specialty. Then, my lord, page 70, third line. That is where, my lord, the petitioner would devise his own method of drawing up the seniority. What he says is, when all of us are recruited, all of us have one common date of recruitment, then you combine all the professors, vacancies in the professors. You combine the vacancies in the cadre of professors across disciplines. Grant this promotion to that cadre notionally and count that as the date. May I just read that from the third line? The making of combined seniority list of professors involves redrawing of seniority
imagining as if all the lecturers, assistant professors in all the subjects are a common cadre. Working out on notional dates of promotion to the higher level of associate professor and professors on the basis that all lecturers, assistant professors, irrespective of the subject in which vacancy are arisen, are eligible to be considered for promotion based on the length of service subject to absence of disability, such as pending departmental inquiry, criminal inquiry, or adverse remark. First to the rank of associate professor and then to the rank of professor. And then arranging the names of professor in the order of such dates of promotion. Therefore, the admitted case before your lordships today is, at any rate, the seniority cannot be counted from the date of promotion. It has to be, my lords, from a notional date by combining all the vacancies of professors across disciplines and then granting notional promotion without reference to the actual date of promotion. This is the first pleading. Then, my lords, what your lordship, my lord, would find at page 74, para 16 is the reference to the judgment in N. Ramchandra Rao, which is marked as an annexure, my lords. I'll just come to that. This was the entire premise. Please don't count the date of promotion of professors, the date of entry into the cadre of professor, but the actual date of entry into service in the institute is what is to be counted. I'll just point out, my lord, what the objection of the institute was. May I just draw your lordship's attention to page 206. Two important, before taking your lordships through the rules, two important things which the institute pointed out. The first thing, my lord, the institute would point out is at page para 26, page 217. What institute would say is, petitioner says, yes, it is by way of direct recruitment, but we have become autonomous in 2008. There are so many persons who are absorbed. Now, if the in the original cadre, seniority is to be assigned on the basis of merit in KPSC, I can't possibly do it because others are absorbed. They are not even directly recruited into this cadre. They are absorbed from the health and family welfare. Therefore, what is the date I should assign as per KPSC ranking? That is not a possibility at all. And they would place reliance on the bylaws to say it is date of entry into the cadre which would govern the seniority. I would also file my objections more or less on similar lines, but specifically saying there is no merit list by KPSC at all. There is no combined merit list, and I have produced that annexure also. To negate this, three contentions of the petitioners. One is straight away on the judgment in Ramchandra Rao. I'll just take your lordship to that. Point out why it is not applicable, because learned single judge has heavily relied upon this judgment. Page 199. But I don't mean to read the head note. I'll take a lordship to the specific paragraph, but head note itself is sufficient. Ramchandra Rao was dealing with the case where seniority list was made on the basis of specialities. Cardiology was placed first. Persons in the department of cardiology were placed above neurosciences, above psychiatry, so on and so forth.
Those were the rules.
That was not the rule. The institute there, government had done it on the basis of the specialities. Seniority list was not on the basis of entry, but on the basis of specialities.
One over the other.
One over the other. There was no rule, to that extent. It is in that context, the litigation arose. That may I just draw your lordship to the head note itself. Service law, seniority and promotion. Speciality by seniority. State medical service. Promotion to administrative post, additional director of medical and health, should not be on the basis of seniority determined in order of speciality. That would make it arbitrary. Now, my lord, I'll take your lordships to the facts. Page 6, page 201, para 6, para 4. All civil assistant surgeons, including assistant professors and tutors, are eligible for promotion as deputy civil surgeons on the basis of seniority of assistant professors, civil assistant surgeons, and tutors. It is said that posts of deputy civil surgeons are not cadre posts. They are just like selection grade posts covering 15% of the total cadre strength. They are both common in teaching cadre as well as non-teaching. Then para 6, Maharaj, are the rules. But next page, para 11. The question actually was slightly different. Para 11, they would extract the rule number, category of post and method of recruitment. By promotion from among holders of posts of professors in category 2 and 3, with not less than 3 years of service, of which at least 2 years shall be in one of the said categories. Para 13.
By promotion from among holders of posts of professors in categories 2 and 3. With not less than 3 years of service, of which at least 2 years shall be in one of the said categories as on January 1 of July.
They should have 3 years of service. Now the question is 3 years in category 2 and 3 or in the lower cadre also. That is forthcoming in para 12 and 13. Para 12. There are 3 requirements for eligibility for consideration of promotion to the category of additional director and equivalent. He should be in the cadre of 2 and 3 class. He should have been a minimum service of 2 years in the said category. He should have total service of not less than 3. 2 years of service in the category appears to me 2 years service as professor, and this is not in doubt or dispute. The dispute, however, is about the requirement of service of 3 years. Whether that service should only be in class 1, category 2 or 3, or inclusive of service in class 3. Class 2 is the question for consideration. That was the dispute.
Okay.
Now,
That's different.
yes. Now that was the question.
Means it can be 3 years of total service. Yes.
No such, my lord, in my respectful submission is the dispute here. Now the finding, my lord, is at page 204, para 17. I'll read the entire paragraph for clarity.
Yes.
Though the relevant portion is at the very end of the paragraph. Furthermore, Rule 2 does not expressly exclude the service in class 2 cadre for preparing panel for consideration for promotion to post with which we are concerned. We also consider that it would be unreasonable and unjust to exclude the service and overlook the vertical seniority in the substantive cadre to which everyone was selected by the Public Service Commission. In medical profession, there are specialties and specialties, but it is generally accepted that they are not of equal importance or utility. However, the promotions are allowed on the basis of respective specialty and the availability of promotional vacancies in such specialties. A junior with relatively less important specialty may be fortunate enough to get a quick promotion than a senior with a different specialty. We are of the opinion that juniors who get accelerated promotion on account of fortuitous circumstances, depending upon their specialty and availability of vacancies in such specialty, should not be allowed to march over their seniors for appointment to administrative posts. Any advantage gained by juniors on such fortuitous circumstances of having some specialty and promotion should not impair the right of the senior for promotion to post with their specialty or teaching experience is not part. The seniority determining the order of specialty should not therefore be the basis for promotion to administrative post. Any rule providing for the contrary may be vulnerable to attack on the ground of arbitrariness. Therefore, my lords, in my respectful submission, what Ramchandra Rao was dealing with was arrangement of names in the order of speciality and not, my lords, on the basis of the seniority or the actual date of entry into service.
Well, as a matter of fact, this principle is what is found fault with in this judgment is still being practiced today. If your lordships were to see the seniority list of government pharmacy college, it is on the basis of specialty and not on the basis of income. Now, my lord, it is in that circumstance, my lords, this judgment was rendered. Now, my lords, this judgment, the ratio, my lord, apparently is drawn into the writ petition to say that when we were originally recruited in KPSC in the year 1990, the writ petitioner was placed above me, my lords, in the so-called merit list. Now, my lords, merely because he is in a different subject, he did not get professorship, my lords, on the date on which I got. I got promoted much earlier than him. Therefore, my lords, in the list of professorship, I was placed above. He challenges it on the ground that in the original merit list, I was above. Therefore, at any rate, in the cadre of professor, I should always be shown above him. My lord, if your lordships were to accept this proposition, my lord, please bear with me for a minute. Assistant professor, my lord, has a departmental inquiry and ends in withholding of 3 increments. He gets promoted because of that penalty much later. He ultimately becomes a professor. Now, my lord, he would have served as assistant professor for 25 years, becomes at the 26th year. My lord, I am eligible, I get professorship much earlier. Then, my lords, if what has been held by the learned single judge is to be counted, then at any rate, the moment when he enters professorship, my lords, he'll be senior than the rest of them who have actually become professors by virtue of their merit and dint of seniority.
Now, will you please take us to
Relevant rules.
no, the learned, what the learned civil judge is
Learned,
saying.
let me just draw your attention to the rules and then.
Yes, yes, yes.
Because there's one other thing, my lord, the writ petitioner, my lord, relied upon was an order of the government, which is available in volume 2. The government order is available in volume rejoinder file, page 290, annexure Q. It's in volume 2. Like this government order of the year 2001 was relied upon 293 note. Notwithstanding anything contained in the Karnataka Civil Service Seniority Rules, inter se seniority of professors shall be determined on the basis of total length of service put in cadres of lecturer, assistant professors, and professors. This government order was relied upon. Now, my lord, whether this applies to the Bangalore Medical College or not, my lords, is what has to be seen. I'll just draw your lordship's attention, my lords, to the single judge order as your lordship pointed out, then come back to the rule.
What are the rules?
BMC RI is a separate body. I'll just take a lordship to the government order. Page 115 straight away. It was a government college, became autonomous. 115 volume 1. Clause 7. Seniority, service, and conduct rules. Separate order to be issued in consultation with DPR when it became autonomous. In 2013, Manoj, came the Memorandum of Association and the bylaws, Manoj, which started rules and regulations, page 123. 18, clause 18, subclause 3, Manoj. Page 133. One of the contentions we have raised is, as on the date of writ petition, he was ineligible for any of these dean cum director posts because he had not completed 5 years of professor. Page 133, clause 4. Dean cum director to be appointed must have 10 years of teaching experience as professor or associate professor, out of which at least 5 years as professor. In the particular department, preference shall be given to professors who have worked as HOD. He shall possess minimum 5 years of administrative experience. Now, 20 subclause 2. The second paragraph. The senior-most professor of the institute shall be appointed as principal to assist the dean and director and shall be placed in charge of the duties of dean and director during his leave period or absence.
All these pointed out, my lords, to the relevance of seniority. 21. 21 might have some relevance. The service conditions, including fixation of salary, age of superannuation, conduct of disciplinary and other issues shall be governed by the rules and regulations framed by the governing council. And till such rules and regulations are framed and given effect, the provisions of the Civil Services Act and rules framed thereunder will apply. So it was only a transitory provision. Then, my lords, the bylaws were framed insofar as seniority is concerned. Would your lordship, I'm so sorry, page 164. These are the bylaws. Your lordships will kindly notice, my lords, that the bylaws are not in question. The bylaws are not challenged. Page 164, volume 1. Seniority. The dean from the director from dean of the institute shall prepare and maintain a gradation list in respect of each of the categories of employees and publish the same on 1st January every year. 2. The seniority of employees in each category shall be determined by the order of merit in which they were selected for appointment to the cadre in question. It shall be subject-wise. In respect of teaching cadre, in respect of non-teaching staff, cadre-wise seniority shall be prepared. That I think first 3 sentences, my lord, would suffice of clause 2. Seniority shall be in the order of merit in which they were selected for appointment to the cadre in question. Now, my lord, if the cadre in question today before your lordships is professor, then, my lords, it is the date of entry into that cadre, my lords, that becomes relevant, and that is the relevant date. Now, my lords, clause 3, where 2 persons are appointed on the same day, the seniority between them shall be determined as follows, namely, a member appointed by promotion shall be senior to a member appointed by direct recruitment. In case members appointed by promotion, seniority shall be determined according to the seniority of such members in the cadre from which they were promoted. Now, my lords, this is only in a circumstance where both of us are promoted on the same day, which is not the case here. Third, my lord, in case of members appointed by promotion, seniority shall be determined according to the seniority of such members in the cadre from which they were promoted. Now, therefore, my lords, my submission to your lordships is 2 specifically says it is date of appointment into the cadre, my lords, that is relevant. And the first fundamental principle, my lords, in service law, insofar as promotion is, you get the date of eligibility in the seniority list only on the date you enter the cadre, and not from any anterior date. Now, my lord, if anterior date has to be given, I'm just assuming, my lord, the calculation that I just pointed out, that is, my lord, put forth by the petitioner, is to be done. Rules will have to permit for granting notional promotion from an anterior date, unless rules provide for notional promotion. Well, no notional promotion can be granted from an anterior date. And please see clause 24, my lords. Clause 24 specifically did not mention KCS seniority rule and the government orders. The provisions of the following rules shall mutatis mutandis apply to the employees of the institution: probation rules, conduct rules, performance report, KCSR, not seniority rules or the orders passed therein. All other rules regulating conditions of service of employee, insofar as they are not inconsistent with the provisions of these rules, shall mutatis mutandis apply. Now, one more circumstance, my lord, which the learned single judge holds against me in the writ petition is that by merely opting for a separate for a certain speciality, my promotion to the cadre of professorship is by purely a fortuitous circumstance. And therefore, he says, my lord, it is the entire length of service, my lord, in the institute that is to be counted for the seniority in the cadre of professorship and not otherwise.
But one other thing, my lord, that I wanted to point out was, if that is the case, then the service rendered prior to becoming a professor, my lord, is to be counted. That is the past service. There is no provision is pointed out, my lord, by the writ petitioner to say that the past service rendered in the lower cadre is to be counted. Other than the government order, my lord, which in my respectful submission will not apply because there is a specific rule, to the judgment of Ramchandra Rao, which dealt with an entirely separate issue. Just the findings of the learned single judge. Para 20, page 52. Therefore, just about 4 paragraphs, but I'll just read only the relevant portions in each of them. Therefore, Learned Senior Counsel is right in his submission that what is required to be considered is, as per the provisions contained in C&R. The requirement is that candidates for administrative posts shall be selected based on seniority cum merit amongst the teachers in the same autonomy. In this regard, 5 senior most willing professors as per the cadre-wise seniority list of professors shall be considered by the governing council. Next page, page 28. Last sentence, first paragraph, last. I just read from the top. Second sentence. The requirement under subclause 2 of 21 under the heading seniority of the bylaws of the institute also clearly provides that the seniority of the employees in each category shall be determined by the order of merit in which they were selected for appointment to the cadre in question. It is also clear that it shall be subject-wise in respect of teaching cadre. Therefore, enunciation of the Honorable Supreme Court in case of Ramchandra Rao would squarely apply to the facts and circumstances of the case. Next, it was noticed by the Honorable Supreme Court in so much so that regard being had to the fact that in medical profession there are several specialties in each subject have their own relative importance. It was noticed that there may be some subjects or specialties which may be more important when compared to others. I may have some objection to that finding. It was also noticed that the promotional avenues would open up in each of the specialties for various reasons. It is found that in some specialties, the promotional avenue may not open up so easily, as in case of other specialties. Having noticed all these variables, the Honorable Supreme Court opined that juniors who get accelerated promotion on account of fortuitous circumstances, depending upon their specialty and available in such specialty, will not be allowed to march over their seniority for appointment to administrative. Any such advantage gained by juniors on such fortuities should not impair the rights of their seniors for promotion to post where specialty or teaching experience is not concerned. The seniority determined in the order of specialty should not be, therefore, be the basis for promotion to administrative posts. It was finally declared that any rule provided in the contract. Then, my lord, para 22. In the considered opinion of the court, the observations of the Supreme Court in so on so aptly applicable to the facts and circumstances of the present case. We are dealing with an appointment to an administrative post in the present case. Therefore, having regard to the requirements contained in C&R. Then, my lords, para 23, my lords, is the reliance on the government order. Next is, my lords, the regulations of the NMC. My lords, without even challenge being made to the bylaw saying, my lords, it is contrary. The learned single judge says, my lords, plausibly NMC guidelines may prevail over this, and therefore let us ignore what is in the bylaws. Just one other fact, my lord, I'm not, I made a chart of it which is available before your lordship. Page 232 of volume 1. Just to point out, my lord, if the judgment is implemented, page 232, insofar as the candidate my learned friend is representing and the writ appellant. Petitioner is the writ petitioner who is respondent, Dr. Deepak.
Date of appointment is 31/5/2000, respondent number 3, 29/5/2000. Even if date of appointment is taken, I am senior. Date of appointment as assistant professor, 18/4/2004 was when I was appointed as assistant professor. 2007, associate professor, he was 2009, Manoj, I get something else, and therefore, Manoj, I directly become professor in 2007. He comes 2019. Manoj, he does not say entry into the cadre of assistant professor is the relevant date, though his pleading says. Today, what he wants before your lordship says, the arrangement of the names in KPSC merit list. That should continue, my lords, for the entire length of his service career, and which has actually disputed, saying KPSC has not done it. One, and two, my lords, that cannot be. May I just read that. Just quickly, my lords, I'll not trouble your lordship with the list, but one is Jagdish. Wait. Sorry, just give you a call. Sorry, I just. Jagdish and para 9. I am relying upon Yashbir Singh. Madam, I'll give you Yashbir Singh because this is what is relied upon the para 14.
Jagdish Chand.
Para 9. Jagdish Chand, I'm relying upon Jagdish Chand, which relies upon Yashbir Singh. I'm only reading the portion of Yashbir Singh, Manoj, para 14. Seniority ordinarily reflects length of service in a particular cadre or grade. It is generally regulated by service rules or, in the absence of rules, by executive instructions. By and large, such rules provide for determining seniority with reference to the date of appointment. But there are instances where rules provide for determining seniority with reference to the date of confirmation. Normally, when a person is promoted or placed in a higher grade, his seniority is determined with reference to the date of such promotion or placement, unless the relevant rules provide to the contrary. Seniority in the lower grade has no meaning for determining seniority in higher grade, except for determining inter-se seniority. Now, my lords, here what is relevant is 5 senior most professors. Now, therefore, what would become relevant, my lords, is only the date of entry into the cadre of professor. My lord, just to understand, my lord, in our legal setting, may I give this example? A direct recruitment to a High Court judge as against the promotee from the district cadre. Now, if all of us are being considered for promotion as Supreme Court judges, then the length of service in the district court, my lords, is not counted. All India seniority of High Court judges is from the date they enter the High Court judges cadre, and not, my lords, from the date of district judges seniority. Therefore, my lords, it is in that
Yes.
that Ajit Singh para 23, my lord, I'll not trouble your lordship, but I have marked that portion. Internal page 227, para 23. Well, they pivot the finding at para. Yes, so sorry. I'll just share this. Take the citation. Can you just remove the citation? Sorry. It's on my part.
Yes, sorry.
Just para 23 of
Para?
23 of Ajit Singh. Ajit Singh 2.
Yes.
Constitution Judge bench decision. Para 23. Page 227. Where promotion avenues are available, seniority becomes closely interlinked with promotion, provided such a promotion is made after complying with the principle of equal opportunity stated in so on. For example, if the promotion is by the rule of seniority cum suitability, the eligible seniors at the basic level as per seniority fixed at that level and who are within the zone of consideration must be first considered for promotion and be promoted if found suitable. In the promoted category, they would have to count their seniority from the date of such promotion because they get promotion through a process of equal opportunity. Similarly, if promotion from the basic level is by selection or merit or any rule involving consideration of merit, the senior who is eligible at the basic level has to be considered and if found meritorious in comparison with others, he will have to be promoted first. If he is not found so meritorious, the next in order of the seniority is to be considered and if found eligible and more meritorious than the first person in the seniority list, he should be promoted. In either case, the person who is first promoted will normally count his seniority from the date of such promotion. There are minor modifications in various services in the matter of counting seniority of such promotees. But in all cases, the senior most person at the basic level is to be considered first and then the others in the line of seniority. That is how right to be considered for promotion and seniority attached to such promotion become important facets of fundamental right guaranteed under Article 16(1). Therefore, my lords, all throughout what is recognized is from the date of entry into the cadre of professor, whichever is the relevant cadre.
Yes.
Therefore, my lords, my submission is that the learned single judge, my lords, completely fell in error in relying upon the judgment in Ramchandra Rao because it was dealing with an entirely different question and an entirely different seniority list.
Yes.
Here, my lords, admittedly the seniority list is not on the basis of speciality. If that was so, my lords, Ramchandra Rao's judgment would apply, not other. That means.
Yes.
I appear for contesting respondent number 4, my lords, was the writ petition in the first writ petition, 8306. There were 2 writ petitions, combined order was passed.
You are in?
I am
appeal?
in the writ appeal, my lords, I am respondent number 4.
Yes.
Yes,
The petitioner.
petitioner in WP 8306. my lords. Yes, my lords. May I, my lords? Lords, first and foremost, my lords, all the arguments of the appellant would hold true. The argument that for all the promotions, the feeding cadre is a ticking point would hold true, my lords, only in case of promotion to the next post, say from assistant post to professor or associate and then professor. Right now, my lords, we are considering appointment to administrative posts. It is not the normal promotion, my lords. Therefore, all the judgments also not subject to me reading because he didn't have these copies, not requisite copies. All of the judgment which read was to the next post. It was either seniority, then would be reckoned with whatever he argued. Lords. Here, my lords, it's administrative post. Rightly so, my lords, without again troubling your lordships with the Ramchandra Rao judgment. What was dealt, my lords, there what happened, my lords, civil assistant surgeons who were appointed along with the other contesting appellants, my lords. They were denied promotion, my lords, from the date of their entry. and only other people were considered, my lords. What Supreme Court largely said, my lords, in para 17, which was read out, was that appointment in substantive cadres have to be considered when it comes to the appointment to the post of administrative post. It's unlike others. Because, my lords, the reason is this, my lords. Now, right now, keeping an example of the appellant and me, my lords. Appellant and I started our career on 29/5/2000. I will take a lot to seniority list. Both, my lords, started the career on 29/5/2000. Lords. He's in the Department of Biochemistry, and I am in the Department of Orthopedics. We started our career on the same day, my lords. He gets promotion to the post of professor first, my lords, in the year 2007. And I get promoted to the post of professor only in the year 2016. Lords, this is because biochemistry, my lords, he got promoted early for whatever reasons, lords, vacancy in his department, whatever, lords. Therefore, my lords, Honorable Supreme Court says that on account of fortuitous circumstances, if somebody has, my juniors have accelerated, they are the example of juniors. Of course, in my case, we're contemporaries who entered together, my lords. If he was promoted to the post of professor first, and I got promoted, in our case, my lords, 2000, though he was appointed in 2007, my lords, his pay scale for professor was given only in 2009. Because 7 to 9, they kept him only because to satisfy a certain number of professors in a particular department, my lords, I'm told. I'll take a lot of those pleadings. Therefore, my lords, from 2007 to 16, I did not get. Not that I was less meritorious or was less senior. It was
The rules say may be irrelevant.
Yes, my lords, I will take a lot. Why I'm giving this, my lords, a background, because why Honorable Supreme Court stresses on fortuitous circumstances is this because of this, my lords, that you have to ignore the circumstances under which he became professor first and I become whenever later, my lords. But when it comes to administrative post, it has to be the entire length of service rendered by particular
It
candidate.
specifically says about this post.
Yes.
Let's go to the.
I will. But C&R rules, my lords, which was read out to your lordships,
Yes.
is at page 168, and the relevant portion your lordships read, my lords, it has page 170, 170. Subsequent the income director. If I may read all the points, my lords, on the right-hand side, there are 1 to 6, my lords, all are relevant. May I, my lords? First one, candidates for the said post shall be selected based on seniority cum merit from amongst the teachers in the same autonomous institution. So first criteria, seniority cum merit, my lords, in the first point. Second, my lords, 5 senior most willing professors as per the cadre-wise seniority list of professor shall be considered by the governing council of this appointment. Note this word cadre-wise seniority list of professors, I will take a lot of relevant rules, which says it has to be combined cadre-wise list. It cannot be read just the cadre list. It has to be combined cadre list. Number 3, my lords. May I, my lords, continue. Candidates shall have administrative experience either as medical superintendent or as head of the department or as professor at least for 5 years. 4, candidates shall satisfy Medical Council of India norms for appointment to the said post. 5th, maximum upper age limit for the said post shall be 2 years earlier to superannuation. If I'm not still 58 years, I can apply for it. Candidates' probationary period must have been declared. Now, my lords, if I may take a lordships to 2 conditions. My lords. One is point number 2, that's 5 senior most willing professors as per cadre-wise seniority list. And in the first point, it said seniority cum merit. And the 5th point, my lords, was that candidates shall satisfy Medical Council of India norms. I'm straight away taking a lordship to what are the Medical Council of India norms. Lords, I am sure it cannot be the case of the institution or the appellant that bylaws prevail over National Medical Council rules. Lords. May I request your lordships to kindly come to page 295 of the appeal memo, which are the NMC regulations. Lords.
Yes.
295. Lords, it reads, lords, on top, lords. Short title and commencement. These regulations may be called Teachers Eligibility and Minimum Qualifications Medical Institution Regulation 2021. They are bound by this. May I take a lordships to para 3.4 minutes, not 3.6 minutes, deals with Dean cum Director.
Yes.
May I read minutes? The position of Dean Director Principal of Medical Institution should be held by a person possessing recognized postgraduate medical degree from a recognized institution with a minimum of 10 years teaching experience as professor, associate professor in a medical college institution, out of which at least 5 years should be as professor in the department. Appointment to these posts shall be made on seniority cum merit basis. The post of Dean, Director, Principal of Medical Institution is a full-time administrative post and they shall not hold any other post. Then the next minutes, 3.10 is straight on the point minutes. May I read 3.10 clause? It says appointment to these administrative posts in government institution, including the in-charge arrangements amongst eligible candidates, shall be based on inter-se vertical seniority based on date of entry in the institution service. Well, the word used here is inter-se vertical seniority. This was never uttered by the appellant. The requirement, therefore, is just not the seniority list. It is an inter-se vertical seniority list. Therefore, my lords, how it is to be done? And my lords, the word is from the date of entry into the institution of service, not to the cadre of professor. Because here, my lords, we are dealing with appointment to the administrative post. Now, in conjunction with this NMC rules, my lords, this wasn't read out, my lords. They are bound by this. And this, the institution also did not deny their objection, my lords. Bylaw, in my respectful submission, my lords, cannot override NMC regulations. One.
We challenge the bylaw.
I did not, my lords. I need not challenge bylaw, my lords. I'll take a lordship to that relevant clause which was read out, my lords. The reason I'm saying I did not challenge. Now, my lords, coming back to other regulations, my lords, the 2001 regulation which was read out by my learned friend at page 290, my lords.
Yes.
Sorry, page is missing from everyone.
Which one? The comment.
Yes, yes. Lords, these rules, lords, at page 293 are the Karnataka Medical Service Teaching and Technical Personnel Medical and Dental College Recruitment Amendment Rules 2001. Lords, a doubt was raised, lords, it's not applicable. They are applicable. Institution is not denied, lords. In the note appended to that rules, lords, it says, notwithstanding anything contained in the Karnataka Civil Services Rules 1957, inter se seniority of professors. Lords, this I'm reading in conjunction with 3.10 of the NMC regulations, which says inter se seniority of professors, verticalist. Now, when it comes to professors, shall be determined on the basis of the total length of service put in cadres of lecturers, assistant professors, and professors. Lords, this does not say only, my lords, from professors. What was challenged in the writ petition, my lords, was a seniority list, which was prepared only based on the seniority from the date of appointment as professors, contrary to this requirement, my lords, which is the entire length of service.
Yes.
Therefore, my lords, without now reading Dr. Ramchandra Rao's judgment, my lords, going by the C&R rules, my lords, which say that seniority come merit, and my lords, that it has to be by NMC regulations. These readings, my lords, 3.6, 3.10, and 2001 appended note provide, my lords, that in case of administrative post, it has to be inter se vertical seniority list and not just a seniority list. Now, my lords, what was done, my lords, in the writ petition was, my lords, that only from date of professorship was considered. But in fact, what the institution had done was on an earlier occasion, they had in fact prepared a seniority list based on the inter se vertical seniority list. Annexure J of the writ petition, my lords, was a correct list published by them, my lords. Page 175, my lords.
Yes.
Yes, my lords. It was on 2/11/2017, my lords. A seniority provisional vertical seniority list was published, where, my lords, they had considered in a common combined vertical inter se seniority list, my lords, except for some date of entry, except for the small discrepancy. But, my lords, your lordships may kindly see immediately next annexure K, my lords, it was withdrawn without giving any reasons, saying that it on technical grounds. Page 182, my lords. I'm sorry, it is in Kannada, my lords. Probably. They withdrew it, my lords. I don't have the translation. Yes. They do not deny that, my lords. It's not, so they do publish a list, which is in terms of inter se vertical seniority. But they withdraw it without any reason, technical, saying it's technical. There's no, this is not denied, my lords.
Yes.
Now, my lords, I would request you lordships to permit me to read Ramchandra Rao, because the portions I wanted to read were skipped. Page 199, my lords. It starts at 199. Let's hear, para 3 is the facts at page 200 minutes. It is exactly similar to belows. May I read just that paragraph? All the respondents were originally recruited as civil assistant surgeons upon selection by the State Public Service Commission. The minimum qualification for civil assistant surgeons is MBBS. The post of civil assistant surgeons is equivalent to the post of assistant professor. They are intertransferable post. Here is the fact, notes. What happened here, notes? The tenure in this civil assistant surgeons was not considered. And straight away, my lords, other posts were considered. Para 6, my lords, deals with what were the rules there, my lords. There, my lords, they considered branch 1, branch 2, branch 3, and only branch 1 was discussed, my lords. Teaching cadre was discussed. Teaching cadre in turn, my lords, was bifurcated into two lists, my lords. Class 1 and class 2. Class 1 consisted of category 1, 2, 3, and category 1 was the administrative post, my lords, additional director of medical health. Category 2 and 3 were professors, my lords. In class 2, my lords, category 1, assistant professor clinical. These respondents, they, my lords, whose entire length of service was denied, fell in class 2. And what fell for consideration was, my lords, whether experience only in category 2 and 3, that of professors. Lords, if your lordships want, may I continue tomorrow, lords? If there's a time constraint for the court, lords, I will continue. Yes, lords. I will continue.
Serial number 4, Mel.
Could it be at 2:30 minutes?
30 we cannot.
Please edit. Edit.
Serial number 4, Mel.
Serial number 17.
Serial number 4, pension matter, since 4 times it has been adjourned, Mel. Tomorrow it may be.
Yes.
Lord, seal number 17, my lords, tomorrow they are going to, Lord, seal number 17, they're going to announce the list.
Court officer.